Thank you, Sarah, and good morning or good afternoon, as the case may be, to all the participants for the third hearing in a case between Angel Samuel Seda and others versus the Republic of Colombia, ICSID case number ARB 196. I have in front of me the list of participants. The tribunal is complete. Sarah is present. I hope that the court reporters, David and Dante, are with us, and also the interpreters. May I ask first the claimant to confirm that all the participants listed on the list of participants that was circulated are connected, including the party representatives, Mr. Malou?
Yes, Mr. President, I believe everybody who we indicated would be participating is on currently.
Very good. And for the respondent, Mrs. Bani Fatemi, the same question.
Good afternoon, Mr. President and members of the tribunal. I confirm that we're all here. Not everybody is necessarily online, but those who were expected to be are. So we can proceed.
Fine. So we can proceed, and the agenda provides for housekeeping issues to be addressed first. Are there any housekeeping issues that we should talk about, Mr. Malou?
None from claimants. Thank you, Mr. President.
From the respondent?
None, Mr. President. Thank you.
Thank you very much. Now we will start with the U.S. submission, and I therefore turn to the representatives of the U.S. Are they connected?
Yes, Mr. President. My name is Lisa Grosh. I'm the Assistant Legal Advisor for International Claims and Investment Disputes within the Legal Advisor's Office at the State Department. I think I'm joined by some of my colleagues, Mr. Daly, Mr. Peralta. I don't know if others have joined as well.
Okay, so you are complete to proceed, even if some of your colleagues are still missing?
Yes, Mr. President, I am.
Fine.
I will be presenting today.
Very good. So you've seen the agenda. We will start with the U.S. submission, and the floor is yours.
Thank you, Mr. President and members of the tribunal. We appreciate this opportunity for the United States to provide an additional oral submission in this case pursuant to Article 1022 of the United States Colombia Trade Promotion Agreement, or the TPA as we all refer to it. I will make a brief submission addressing questions of treaty interpretation arising out of the claimants and the respondents' submissions dated December 21st, 2022. And as is always the case with our non-disputing party submissions, the United States does not take a position here on how the interpretations offered apply to the facts of this case, and no inference should be drawn from the absence of any comment that I may make on any other issue. Given the narrow scope of today's hearing, I will confine my remarks to the essential security interest exception in Article 22.2b. However, the United States stands by its prior position on the weight due to the views of the TPA parties on matters addressed in non-disputing party submissions under Article 1022. So whether the tribunal considers the concordant interpretations presented by the TPA parties as a subsequent agreement under Article 31(3)(a) of the Vienna Convention on the Law of Treaties, or as subsequent practice under Article 31(3)(b), or both of these provisions, the tribunal must take the TPA parties' common understanding of the provisions of their treaty into account. I also wish to reiterate that nothing in the TPA's text suggests that by granting the Free Trade Commission the ability to issue binding, authoritative interpretations of the TPA under Article 1022(3), the parties intend to preclude themselves from issuing non-binding, but nevertheless authentic means of interpretation of TPA provisions through their submission to investor state tribunals, or to preclude a tribunal from giving such submissions the weight to which they would otherwise be entitled. So with that, Mr. President, I will make 3 points on the essential security interest exception in Article 22.2b and the U.S. treaty practice on similarly worded essential security exceptions. First, the United States reiterates that the language of Article 22.2b and similarly worded exceptions in other U.S. treaties is clear. The exception is self-judging, and once invoked, a tribunal must find that the exception applies. Now, as I have previously explained in our first submission, this follows from the ordinary meaning of Article 22.2's use of the phrase, "it considers." And this is further clarified by the language in footnote 2 that, quote, "for greater certainty," end quote, if a party invokes Article 22.2, quote, "the tribunal or panel hearing the matter shall find that the exception applies," end quote. Thus, once a state to the TPA raises the exception, its invocation is non-justiciable, and a Chapter 10 tribunal must find that the exception applies to the dispute before it. So that's my first point. Second, I would like to address the claimant's argument that the U.S. treaty practice on essential security interests exceptions supports the conclusion that Article 22.2b merely allows a state to apply or continue to apply measures that it considers necessary for the protection of its own essential security interests, but that Article 22.2b does not address the question of liability or compensation. Again, the United States disagrees. Article 22.2b is an exception that is intended to entirely exclude from the scope of the obligations in the TPA those measures covered by Article 22.2b. As there is no obligation under the TPA with respect to covered measures, a claimant cannot establish that per Article 10.16, and I quote, "respondent has breached an obligation under Section A of Chapter 10, end quote, with respect to such a measure. And for that reason, such a claimant also cannot establish that it has, again, per Article 16.1, and I quote, "incurred loss or damage by reason of or arising out of that breach," end quote, with respect to such a measure. Consequently, where such a measure is concerned, there is no basis for a tribunal to make an award of any kind against a respondent. Further, it is a basic principle of state responsibility that there is no obligation to make reparation or restitution unless an injury has been caused by an internationally wrongful act. That is, a breach of an obligation for which a state is liable. In short, because the Article 22.2b exception excludes certain measures from TPA obligations, there can be no finding of liability and no order of reparations with respect to those measures. The TPA parties did not take on an obligation to pay compensation for measures that they consider necessary for the protection of their own essential security interests. So against this backdrop, there was no need for explicit language in provisions like Article 22.2b, stating that once invoked, a tribunal cannot find the relevant measure in breach of any Chapter 10 obligation or order any compensation. Now, I would also like to note that claimant's argument also fails to grapple with the fact that Article 10.26 clearly deprives a Chapter 10 tribunal of authority to order that any measure, essential or otherwise, be withdrawn. Claimants' argument that the text of the Singapore-India Comprehensive Economic Cooperation Agreement contains the type of language that the United States and Colombia should have included in the TPA if they desired to prevent any finding of liability or order compensation is misplaced in our view. That agreement, to which the United States obviously is not a party, has no bearing whatsoever on the US treaty practice. Those are my first 2 points. Third and finally, I wish to address the claimant's argument that Colombia's invocation of Article 22.2b is subject to review by this tribunal for good faith. The United States, of course, accepts that its treaty partners are obligated to implement their treaty obligations in good faith, and indeed, we would expect them to do so. But that is not the same thing as saying, however, that a tribunal is authorized to assess whether a treaty partner has done so. Indeed, the words that it considers in Article 22.2b, as well as the text of footnote 2, make clear that it is not for a tribunal to determine whether the exception has been invoked in good faith. Instead, it is solely for the state parties to the TPA to ensure that the provision is invoked in good faith. Mr. President, members of the tribunal, in concluding, I would emphasize that the United States stands by the interpretation set forth in its written submission, as well as its first oral submission, although we did not address those issues today. With that final observation, I will close my remarks. Mr. President, I thank the tribunal for the opportunity to present the views of the United States on these important interpretive issues.
Thank you very much. I turn to my 2 colleagues to ask whether they have questions to the US representative.
I have one, if I may, Mr. President.
Yes, Mr. Ponce.
Mrs. Grosch, can you hear me?
Yes, I can.
I'm Charles Ponce, one of the 3 arbitrators in this panel. I'd like to continue your line of thought with regard to the 3rd point you made. You said there is absolutely no room in the language of the treaty for any interpretation by the arbitral tribunal, which par hypothèse, I'm not saying, of course, that this would apply in this case, it's purely hypothetically, but if par hypothèse, an arbitral tribunal were to be convinced that the exception, that Article 22.2b is invoked purely in an arbitrary, capricious manner, simply to prevent an investor from seeking justice, you made the point that the arbitral tribunal had no authority to review that, and that it would be for the states themselves. Does that mean that the investor then would have to go to its state, in this case, the United States, to seek the application of the provisions of the treaty that provide for arbitration between states? Or does that mean that the investor is simply left to forget about any possible international law remedy? What is the consequence of your, and I'm sorry for being a little long-winded, but what is the consequence of your statement that it is for the states and for the states only to resolve the matter?
Thank you, Mr. Ponce. So yes, our view is that the essential security interest provision is completely self-judging, and there is no room for the tribunal, for a Chapter 10 tribunal, to address good faith. Yes, I just wanted to restate the underlying proposition there. And so, as I understand your question, you're wondering then what efforts or avenues does either the investor or generally the United States have for addressing a potential bad faith invocation of the essential security exceptions. That's as I understand your question. So I don't believe that we have a specific process or avenue in mind, but certainly it might be up to the investor, in this case, a U.S. investor, to come to the United States and raise its concerns about the fact that the exception has been raised in bad faith. I think it's also, in this particular situation, could be up to the United States to just raise this sua sponte directly with its treaty partner.
Doesn't that mean, sorry to interrupt you, but doesn't that mean that in effect, the determination of the existence or absence of good faith would be delegated to the United States?
Yes, that's what essentially my third point was, is that we expect, the United States expects all of its treaty partners, and here Colombia as well, to apply and implement its treaty obligations in good faith. But that is a matter that is reserved to the states to a treaty.
You would agree with me, wouldn't you, that in the hypothetical situation of a bad faith invocation of 22(b) or the equivalent in another BIT, this would leave the investor with very, very little protection indeed, because you'd be completely dependent on the finding of its own state, in this case the United States, that there was a breach of the general duty of good faith. And if the state, if the investor's state, in our case the United States, says no, we don't think it was in bad faith, that's the end of the story.
Well, again, the treaty partners have agreed to obligations to provide protections to investors and such, but they also have very much reserved certain exceptions to those protections. And so if one of the measures that that is invoked by the investor is governed by the essential security exception, and that is essential security exception, as intended by the two state parties here, is meant to completely take that out of the treaty, then yes, the investor has limited avenues in terms of how it could pursue its interests.
And one last question, with the President's permission. What is your position as to whether or not the essential security provision can be waived, whether implicitly or explicitly?
Our view would not be that the essential security exception could be waived. There is no provision in the treaty for that. The treaty language is clear. It is for one of the parties to invoke it if it considers that it is necessary, that the measure is necessary in its essential security interests.
Thank you.
Other questions?
No questions from me at this point, Mr. President. Thank you.
Right. Mrs. Scott, just a question from my side. When you consider Article 26 of the Vienna Convention that provides that the states should apply the provisions of the treaty in good faith as a general rule, and this is also accepted in international public law, how does this interplay with your position? I mean, we understand you say it's your expectation that the treaty partner implements the measures and the provisions of the treaty in good faith. Yes, but there's also this general principle expressed in this Article 26 of the Vienna Convention. Could you elaborate on this?
Yes, thank you, Mr. President. Yes, as you reflect, the Vienna Convention does have an element of good faith, that the treaty parties to a treaty are to implement their treaty obligations in good faith. This is a position that the United States feels strongly about. But again, consistent with what my remarks provided for earlier, this is an obligation that runs between state parties to a treaty. And therefore, it is to those state parties, either diplomatically or otherwise, to address if one party believes that the other party has not implemented or has applied the treaty in bad faith. And there are obviously avenues that states can take, whether it's diplomatically or if there are specific provisions in the treaty at issue. So this is a position that the United States has taken, not just in this case, but in other cases as well.
And are you saying that such good faith obligation does not apply to the beneficiaries of treaties, meaning the investors that are granted protection under treaties?
I'm sorry, could you repeat that question?
Are you saying that the good faith obligation laid down in Article 26 of the Vienna Convention applies only in the relation between the states and the expectation, as you say, to implement the provisions in good faith? Or is there also an element of beneficiary protection, meaning the investors that are also referred to in treaties, do they have a beneficiary status, meaning that they're also recipients of a good faith obligation?
Mr. President, I would say that the first part of that proposition is correct, that it really is to the state parties that have the obligation to the other to implement the treaty in good faith. That is the United States position. With respect to a good faith, and I should just note there that there are lots of treaties that do not have dispute resolution mechanisms. Sometimes there's no state-to-state resolution mechanism, and many times there may not be. There are treaties where there are no dispute resolution mechanisms that would involve interests of investors. So with that said, we do not view that there would be some kind of a beneficiary interest. That's obviously something that we could include in express treaty language, but it is not in this treaty and not in most treaties, as I understand, or US treaties.
Okay, thank you. Any follow-up questions triggered by the questions put by the tribunal from the parties? A claimant?
Mr. President, I plan to address the comments raised by the US in my submissions, if that's most convenient for the tribunal.
It certainly is. Respondent?
No questions, Mr. President. Thank you very much.
Thank you. Then we thank the US representatives for their intervention, their submission, and their answers to the questions put by the tribunal. We have now on our agenda break of 15 minutes. I think we could skip that if, or shorten it at least. Mr. Moulou, are you ready to proceed with your opening presentation, or do you need 5 minutes or even more? I mean, the break has been put on the agenda, so it's up to you to tell us how much time you need.
Just 5 minutes, Mr. President, because we will be circulating our presentation, and so just to allow us to circulate that and to allow all of you to
very good.
Download it if you so wish. So 5 minutes is more than sufficient.
Yeah, very good. Thank you. Yeah. Sarah, are we all back?
Let me just check. Yes. Yes, the breakout rooms are all closed.
Good, very good. So, Mr. Malou, the floor is yours for your opening presentation.
Thank you very much, Mr. President and members of the tribunal, for indulging us with a third hearing. You must be sick of hearing from us by now, but hopefully we can keep your attention for another 90 minutes this morning or afternoon, as the case may be. Members of the tribunal, where I'd like to start is to take a step back, talking about the tribunal's questions, and then we'll run through the other issues that I have identified on this table of contents and show you how the new evidence that's been presented to you and been submitted post-hearing has had no impact on any of the key issues that the tribunal needs to decide, and in fact only bolsters the claims that the claimants have made. But let me start with the tribunal's questions. And by the way, a number of these my partner, Ms. Champion, will address, so you'll get to hear from someone other than me. The first question that the tribunal asked is, what is the legislative purpose of the Colombian asset forfeiture law? Now, this one, I think the answer is fairly clear, and you have it from the two experts that made reports and were submitted by the claimants in this arbitration. The first is by Dr. Medellin, who you unfortunately did not get to hear from in person, but he is the former Minister of Justice of Colombia. He is known to be the father of the asset forfeiture law, and he was not called for cross-examination, and his testimony remains unrebutted. But he really is I would say, the most knowledgeable person in Colombia on the asset forfeiture law, being the one who authored the original asset forfeiture law. And he says that the purpose of the asset forfeiture law was to attack illegal activities such as drug trafficking and consequently obtain social and economic stability in the country. And he also explains that under Article 27, it says that there are certain fundamental guarantees, certain governing standards that supersede everything else in the Act. And one of those governing standards and fundamental guarantees that was meant to prevail over any other provision in the code, those are his language, that's his language, was that the right to property lawfully obtained in good faith without fault must be protected. Due process rights must be protected. The presumption of good faith must be recognized. Those are all within the governing standards and fundamental guarantees that prevail over any other provision of the code, according to the father of the asset forfeiture law. Dr. Wilson Martinez, who had a role in authoring the most recent iteration of the law from 2014, he explains in his testimony that one of the reasons for the updating of the law was to clarify the nature of the scope of and expressly recognize and protect the rights of third parties acting in good faith without fault. That was one of the reasons for the updates, to ensure that those who were acting in good faith, their rights were adequately protected. And that makes complete sense. All of this makes complete sense, because if the goal is to protect society from narco trafficking, you don't advance that goal by taking property away from those who bought it in good faith. And I'll come back to this later, but in fact, the investment treaty itself, the free trade agreement that is at issue here in this case itself, recognizes that that Colombia as a society wanted to move on from narco trafficking and the drug trade that had plagued its country. And one of the ways it thought it could do so was to foster legitimate foreign investment. That's in the second preambulatory clause. It's right up front in the entire treaty. That's what it says. And I'll show you that later. Dr. Martinez explains that the code provides a presumption of good faith as a guiding principle in the proceedings. And as a rule, it considered predominant over all other rules in the code. Any reasonable doubt as to good faith must be interpreted in his or her favor. Prior slide 8. Sorry. You can see this here from Dr. Wilson Martinez's first report. Moving to slide 9. These are the actual provisions in the code. And you can see there's Title 2, Guiding Rules and Fundamental Guarantees, right up front. Article 3, asset forfeiture shall have as its limit the right to ownership legally obtained in good faith without fault. So if we're looking at what is the purpose of the law, it is to advance the fight against narco trafficking, but not at the cost of affecting the rights of good faith third parties without fault. Good faith is presumed, and it is a guiding rule that is compulsory and must prevail over any other rule in the law. But moving on from the guiding rules and fundamental principles, the other provisions in the code, even ones that were invoked by Colombia in this case, also embed within them to reinforce the principle of good faith without fault and those rights being protected. Precautionary measures. That's how the property was taken in the first place, the invocation of Article 87. And the very last sentence of Article 7 makes it crystal clear that in invoking precautionary measures, in any case, the rights of third parties acting in good faith without fault must be safeguarded. Article 118, purpose, talks about the purpose of, it says the initial stage, which is after the precautionary measures, you have the initial stage where you investigate, and that's what kicks off the process. We remember that Ardila Polo showed up, invoked precautionary measures and put the padlock on the door, sent everybody home, and then engaged in this initial stage investigation. Well, what was she supposed to do during that initial stage? 118.5, search for and collect the proof which makes it possible to reasonably conclude that there is no good faith without fault. That was supposed to be done right at the beginning. It wasn't done. But that is one of the key purposes of this law. The purpose of this law is to ensure that in invoking asset forfeiture, in protecting society against narco trafficking, etc., it does not do so at the cost of good faith third party purchasers. And Article 124 and 152 confirm that. And it says that the burden of proof, it's the Attorney General of Colombia is the one that has the burden to identify, locate, gather, and file the elements of proof, which show the existence of some of the grounds set forth in the law, and that the affected person is not a bona fide owner of rights without fault. They have to do that up front. It's the burden of proof is not on the third party, it's on the state to establish up front that they're not affecting the rights of bona fide owners without fault. So if we're answering the question of what is the purpose of the law, what is the purpose of the law? That's the first question. We'll go to the next question. What is the precise essential security interest that the respondent is invoking in the present arbitration? Well, which is on the next slide, to what extent are the legislative purpose and the essential security interest similar? It must be the same thing, right? Based on what they've kind of said. The purpose of the asset forfeiture law, as we've said, is the things on the left. And what Colombia has articulated as the purpose of its essential security interest are reflected on the box on the right, and they do match up. They do align. It is to protect, and it makes sense, right? It's to protect society against the dangerous effects of narco trafficking. We understand that that's the purpose of the asset forfeiture law, and that must also be the purpose of the essential security interest. But this is critical. In both cases, it must also then protect the rights of good faith third parties, because taking property from good faith third parties does not advance that essential security interest. It cannot. It does. How does it? I still have not heard any reason as to how taking and affecting the rights of good faith third parties can possibly be related to an essential security interest. It Cannot. They're not saying that taking property from good faith third parties is their essential security interest. Affecting the rights of good faith third parties is not the essential security interest. And it seemed at the hearing when, Mr. President, you asked a question of Ms. Banafitemi, that she initially appeared to agree to this proposition. When asked, the law contains this exception that a bona fide purchaser cannot be subject to the forfeiture proceeding. So isn't the expression of the national interest contained in that law with that exception? So in other words, isn't this good faith? And I don't want to be putting words in the tribunal's mouth, but as I understood this question, it was really asking a similar question to the one that's posed before this hearing, which is, isn't there this good faith exception built into this essential security interest? Because that's also in the law. And Ms. Banafitemi interestingly answered, and this seems to confirm our position, well, it's the whole purpose of the asset forfeiture proceeding to determine whether someone is bona fide without fault third party. It's the whole purpose, she says. And then Ms. Banafitemi expounded and said, you have to go through the motions, and the courts are currently seized of the matter. And that's what they're saying. The courts are seized. The courts are making determination as to whether Newport, which is now an affected party, and it was before, it is again, it can make submissions, it can make its view known, and that will be determined. That now that the courts are seized of the matter, we were told that we'll now see whether they're a good faith third party. Well, spoiler alert, you were told last year that within a year you'd know the answer. Well, not an email or a letter or anything has gone out to Newport setting dates for submissions, let alone a determination of the question. It is now a year later. Not one step has been taken in that proceeding to determine whether or not Newport is a good faith third party. They are still waiting. 7 years later, after precautionary measures were taken. And then later, when pressed on this question, Mr. President asked, so on the international law level, we have to look at how does Colombia define its national interest in this regard. So we have to look into the law, and the law provides certain proceeding, certain thresholds, and certain standards and certain protection. But it also provides for this exception, the bona fide acquisition of a possibly tainted property. So my question is, isn't that then part of the consideration that this tribunal has to carry out? And Ms. Banafitemi then resorted to what now seems to be their position with respect to the essential security exception, and says, well, this is in the event that you don't give any effect to 22.2b, which would be a problem because, and she explained why she believed that would be a problem. But her primary position was that, no, we get the right to choose. Once we invoke it, you can't look at anything. And that seems to be an iteration of what we heard this morning from the US government. And I'm going to come on to that. I'm going to come on to that in a moment. But in our submission, the response to the tribunal's third question is clear. To what extent are the legislative purpose and the essential security interest similar? I would say the essential security interest here was the invocation of a particular law. It was the invocation of a law that has certain exceptions. The purpose of that law must then be the same as the purpose of the essential security exception, which is to protect society against narco trafficking, but not at the expense of good faith third parties. And this is on the next slide, on slide 20. Exception does not and cannot apply here. And here I want to address what Colombia has said and what have heard from the US government as to this particular essential security exception. We can go to slide 24. There is not one tribunal that I know of that has taken the interpretation that Colombia and the US government has advanced in this arbitration, that this tribunal can't touch it. In fact, if you look at, and this is a case that is often cited for self-judging essential security clauses. And actually, I'm just going to go, if we can, to slide 26 for a moment, just to show you the provision that's in the GATT that that we're going to be looking at. In Article 21 of GATT, it is a self-judging provision. So it says nothing in this agreement shall be construed to prevent any contracting party from taking any action which it considers, that's the language that the US says is the magic words, right, necessary for the protection of its essential security interests. So that's the provision that these WTO tribunals are interpreting. And in interpreting this self-judging clause, Article 21 of the GATT, we can go back to slide 24 now. This is what WTO panels have said. They've said, applying Article 26 of the Vienna Convention on the Law of Treaties, which says every treaty in force is binding upon the parties to it and must be performed by them in good faith. And in applying that, they say there's a two-pronged test. The first prong, it says at 7.132, it does not mean that a member is free to elevate any concern to that of an essential security interest. Rather, the discretion of a member to designate particular concerns as essential security interests is limited by its obligation to interpret and apply Article 21(b)(3) of the GATT 1994 in good faith. And they talk about it as being a general principle of law as codified in Article 26 of the Vienna Convention. You can see that in 7.132. And they say the obligations of good faith requires that members not use the exceptions as a means to circumvent their obligations in GATT 1994. That, I think, goes to answer the question that Dr. Ponce asked earlier of the United States. You can't use this good faith exception to circumvent your obligations. And so the first question is, do you define the essential security interest in good faith? So you can see at 7.138, they say it applies to the member's definition of essential security interest. That's what you see above in the paragraphs. So you have to define the essential security interest in good faith. And the second part of the test is there the measure that you take, is it plausibly related or rationally connected, as other tribunals have used, to the essential security interest? There's got to be a connection between the measure and the essential security interest. So did you define the interest in good faith? Is the definition of it in good faith? And then is that interest plausibly connected to the measure you adopt? That's the good faith test. And by the way, I just want to make one other point here in terms of what the US government said earlier. The obligations in Chapter 10 are to investors. It's not just to the other state. Quite clearly, the obligations, if you just read them on their face, are to investors. And what you heard the United States say this morning is there's a lot of treaties that don't have investor-state dispute resolution provisions, but this treaty does. And it gives this tribunal, under Article 10.16, the authority, the sole authority, to interpret these protections and to whether or not any exceptions are invoked in good faith. It is within the remit of this tribunal and solely this tribunal to make that determination, because Colombia and the United States authorized and granted that authority to investor-state arbitral tribunals. They allowed investors the rights to invoke that investor-state dispute resolution mechanism and the protections contained in Article 10. And it is an obligation on the state, therefore, and this is Article 26, it says these obligations, and these obligations are to investors, must be performed by them in good faith. That is the obligation. It is an obligation vis-a-vis investors, and it must be performed by them in good faith. In another WTO case, the Saudi Arabia case versus Qatar, and this is at RL 201, the same question came up as to whether or not Saudi Arabia's essential security interest, and in that case, the essential security interest you can see was articulated at 7.280 of the panel's decision. And the essential security interest was protecting itself from the dangers of terrorism and extremism. And Saudi Arabia had basically severed relationships with Qatar in June of 2017. That was the essential security interest espoused. And the measure was to cut off relationships with Qatar. And one of the things it did was it booted, it blocked a Qatari-owned channel from its television, so that folks in Saudi Arabia could not watch this television channel that was owned by Qataris. And the name of that channel was BN. And then there was a Saudi Arabian channel that took the place of this Qatari channel, and they called it conveniently Be Out Q. And the allegation was that there were certain copyright and trademark laws and intellectual property rights that were affected. And what the tribunal said in that case was that the measure taken, which was not implementing and not enforcing certain intellectual property rights, affects not only Qatari nationals, but it affected third parties. They talked about the fact that there was no temporal connection between the non-enforcement of these intellectual property rights and the essential security interest that was being sought to be protected. And they found that there was no rational or logical connection between the measures and the essential security interest. That's the language. No rational or logical connection. And as such, the panel found that there was no good faith invocation of the measure. And so they applied this test. In applying a self-judging essential security clause, the panel in that case found that there was no rational connection between the measure and the essential security interest, and so it does not pass the good faith test. And again, there is no tribunal, no panel, nothing in the record that I am aware of where the interpretation that's being espoused by Colombia and the United States has been adopted by any international tribunal. Rather, there are the examples that we've put in the record, two of which I have just taken you to. And in fact, for that precise reason, when Colombia invoked the essential security interest in their rejoinder, guess what they did? They accepted the good faith test. At paragraph 55 of the rejoinder, this is before we raised it, before we raised the good faith test, they raised it. They said, we're invoking the essential security interest. And as to the definition of Colombia's own essential security interest, it is generally accepted that it's up to the state to define it. The respondent thus enjoys full discretion to define what constitutes its essential security interest to the extent that such definition is done in good faith. That's what they said before we said it. In their rejoinder at paragraph 55, that's what Colombia said. In this proceeding, they now seem to have gone back on what they themselves said, because I think it's crystal clear that they haven't invoked it in good faith. I'm going to come on to that. But they adopted the WTO panel in Ukraine versus Russia test that I just took you to, the two-pronged test, that it must be defined in good faith and that there must be a plausible connection between the measure on the one hand and the essential security interest on the other hand. This is from Colombia's rejoinder, paragraphs 55 and 57. If we go to the next slide, this this goes to the first prong of the test, because it seems, to the extent, and we'll hear from them this afternoon, but to the extent they are defining now their essential security interest as not including a good faith exception, I would say that the first prong, they fail. They have not defined their essential security interest in good faith, because in order to define it in good faith, you must recognize the same exception that is within the law, the asset forfeiture law. It is not a good faith definition to say that we want to stop narco trafficking, but we're going to ignore the protection of good faith third parties. That, in my view, is not a good faith definition of the interest, that first prong of the test, because it doesn't advance the objective. You must recognize the rights of good faith third parties. The law itself, domestic law itself, the domestic law that they're invoking itself recognizes good faith third parties and the rights of them. So the definition of the interest must take into account the rights of good faith third parties. USA case at the ICJ, I think, is instructive here, because, and this was not a self-judging clause, but it goes to the temporal issue, the question of the connection between the measure and the essential security identified. And in that case, the ICJ found the same thing. They say that the measure, in order for it to be taken for an essential security purpose, I think this is an obvious proposition, but it has to have been taken for that essential security purpose at the time that you took the measure. And they looked at the chronological sequence of events in Nicaragua versus the US, and they said it wasn't taken for an essential security purpose because the measure itself was invoked for a different purpose, not the essential security purpose that was then later identified. This is a completely separate point. So I think we prevail just on what I told you, that this essential security exception has not been invoked in good faith, and therefore we're out of it. It doesn't even apply here. But if the tribunal was to find it does apply, we would say you need to look at what does the application of it mean? And the application of it in our submission simply means that it allows a party to apply a measure that it considers necessary for the protection of its own essential security interest. It means what it says. It can apply a measure. Now, I think it's important by way of background here, and I know the tribunal will be familiar with this, so I'll go through it quickly, but the primary remedy in international law for a breach of an international legal obligation is restitution. So it is the withdrawal of the measure. If you take a property, it's to give back the property. That's the primary remedy. Article 35 of the Articles of State Responsibility say that. And damages is it's a backup remedy. Compensation is insofar as such damage is not made good by restitution, or restitution is materially impossible, then compensation is the fallback. But the primary remedy, if I take property, is to give back the property. As under international law, that is the primary remedy. And by the way, that's not just the Articles of State Responsibility. The TPA in this case also says that. And you have to remember, Article 22, the exception that we're talking about, applies equally to the investment protections and the trade protections. And if we go to the next slide, what you can see is Article 10.26 that governs this tribunal says where tribunals make a final award against a respondent, it can award monetary damages and it can order restitution of property. The TPA authorizes the tribunal to do that. With respect to trade panels established under the TPA, again, in the final report, the panel, if the panel determines that a disputing party has not conformed with its obligations, or that a disputing party's measure is causing nullification or impairment, wherever possible, the resolution is that you will eliminate the non-conformity or nullification of the impairment. So the primary remedy in the trade section is withdraw the measure. Why is this important? This is important because the exception then says, no, you can keep the measure. That's what the language that says nothing in this agreement shall be construed to preclude a party from applying measures that it considers necessary to protect its essential security. So what it's saying is that remedy of restitution, that remedy of withdrawing the measure, we're taking that away because we want the state to be able to adopt the measure that it wants to protect its essential security interest. So if we're in a world where the essential security provision is properly invoked, and we don't think it has been for the reasons I've already said, then all it does is it says it takes away Article 10.26b. It takes away the remedy of withdrawing the measure, but it keeps the compensation obligation. And by the way, this is exactly what the Eco Oro versus Colombia Tribunal decided. And it decided this in the face of non-party submissions from the other treaty party, Canada, in that case. Now, this was not a self-judging provision, but that's irrelevant to the question that I'm addressing, which is the remedy. If it is properly invoked, whether self-judging or the tribunal decides it applies in the non-self-judging context, what does it mean? What is the implication of the application of that essential security protection? The Eco Oro versus Colombia Tribunal, in interpreting very similar language, said if we find that it applies, and again, because it was essential security, not self-judging, they would have had to find that it applies. But if they found it applies, what's the consequence? The consequence, they said, was they can keep their measure, but it cannot accept Canada's statement that in such circumstances, payment of compensation is not required. This does not comport with the ordinary meaning of the article. And we say this tribunal should follow the reasoning in the Eco Oro versus Colombia decision in interpreting a very similar provision with respect to the consequence of the proper invocation of an essential security protection. The TPA in other clauses makes very clear when they're trying to do something different, when they're trying to preclude a claim. For example, on slide 40, you have a number of examples. No claim may be submitted to arbitration. That's what they say when they don't want a claim to be submitted to arbitration. They use very different language. You can see that. And that's, for example, in the statute of limitations provision where they say, if 3 years have elapsed, they say in that case, no claim may be submitted to arbitration. And I've given you some other examples here, but it's very clear that when they mean no claim, non-justiciable, they use different language. And just to give you an example of an essential security provision that uses very different language, is the India-Singapore Comprehensive Economic Cooperation Agreement. And the US said this morning, but we're not a party to that treaty. Right, but the point here is when parties want to use more express language and say, for example, that something is non-justiciable, they say it. This treaty provision actually says, we mean it's non-justiciable. So if the US and Colombia want to amend the treaty, they are welcome to do so. But they have not amended the treaty, and it is this tribunal's authority, this tribunal's sole authority to interpret the treaty. And that's what other tribunals have said. In the Infinito Gold versus Costa Rica tribunal, the Semper versus Argentina case, for example, in the Infinito Gold versus Costa Rica case, they said, well, even if there was some by these non-party submissions, if it was considered to now be subsequent agreement for purposes of the Vienna Convention, it would post-date the commencement of the arbitration, and we can't apply that retroactively. So even if there was subsequent agreement, it's subsequent agreement after the commencement of this arbitration, and that can't possibly affect the rights of a litigant. But in any event, these tribunals all say states are free to amend the treaty. That's what the Semper versus Argentina tribunal said. But that doesn't affect the rights that are under the treaty that we as a tribunal have the authority to interpret. We are the interpreter. You, not we. You, gentlemen, are the sole authority that can interpret this treaty for purposes of this dispute. And I think it's obvious that if you were to adopt the blanket exception that's being put before you, it would render completely ineffective the trade promotion agreement. It would be a get out of jail free card, as we've said time and time again. And in fact, it would contradict a very important purpose of this TPA, which is to promote broad-based economic development in order to reduce poverty and generate opportunities for sustainable economic alternatives to drug crop production. That is the object and purpose of this treaty. And in interpreting this treaty, including the essential security provision, this tribunal must have in mind this object and purpose of the treaty: to promote economic development, to move on from drug crop production. That's indeed one of the very objectives of the treaty. Let me pause there, and subject to any questions, I'm going to turn the floor over to my partner, Ms. Champion.
Are you muted, Raheem?
Before you start, are there questions at this point of time from my two colleagues?
Not at this time for me, Mr. Chairman.
Thank you.
Good morning. We thank the tribunal for its time today. I'm going to just cover how the new evidence that the parties have submitted in this case has no impact on Newport's good faith. I want to remind the court of the applicable standard. A decision of the Colombian Constitutional Court that was issued after claimants filed the memorial, but before respondent filed its counter memorial. And this decision tells us a lot about what is required and what is not required to meet the bar of good faith without fault. Colombia did not mention this decision in its counter memorial because it really destroys their argument that there was some obligation to dig up the name of Ivan Lopez 20 years before this purchase occurred. As the Constitutional Court says, the good faith and diligence that may be required of third-party acquirers refers exclusively to assets that are the object of a legal operation. In other words, here, the land, but not to those persons who transfer domain over them. In fact, when someone intends to acquire an asset, it is up to that person to ascertain the legal status of the asset in order to establish the history and the chain of title and tradition. In other words, is title to the asset good? Can the asset be transferred? But not to inquire into the history or personal details of the party that transfers the respective assets to him, especially when, in many cases, the transfer occurs when the state itself has not been able to prove or penalize the perpetration of illegal activities. This is exactly the situation we are facing here. Colombia alleges that illegal activities took place by persons in the history of the title of this property, persons whose names do not appear on the paper. And they also allege that we should have to consult rumors and rely on rumors. The Constitutional Court definitively rejected that. It says, in a scenario such as this, people in legal commerce would be obliged not only to study the titles to assets, but also to perform meticulous investigations into the legal past of the sellers, into any legal disputes they may be involved in different jurisdictions, into the investigations and inquiries carried out by the prosecutor's office in which they could be involved, and even into opinions about said sellers in their communities and on social media. The Constitutional Court rejects this as completely unworkable. It notes that this perspective makes legal trade difficult or impossible, and also imposes unreasonable and unsustainable burdens on individuals which go far beyond the duties that the legislator can constitutionally impose on this. So the Constitutional Court decision is clear. Now, again, at the outset of the merits hearing in this case, Newport was finally recognized by the Colombian courts as an affected party. And the Colombian court based that determination on the 2012 sales purchase agreement, which it said Newport is entitled to participate in the case given that it has a pecuniary right with respect to the affected properties. That's based on the sales purchase agreement. That agreement is signed, then diligence is done on the property. As this tribunal already knows, it's been covered exhaustively, that diligence was extensive. It included diligence on the title, a corporate study of the seller. Corfi Colombiana was hired, ran its own Sarloft process, made a submission to the Attorney General's office listing every past owner of the property, as well as their legal representatives at the time of the inquiry, including La Palma, and everything comes back clean. Now, as claimants experts have explained, including the former Minister of Justice, the date of signing of the commercial trust agreement entered into between Newport SAS and Corfi Colombiana in the year 2013 is determinate. As of that time, the parties to said agreement already had a patrimonial interest over the real property asset. Therefore, it could not be demanded of them that they continue engaging in acts of due diligence regarding a transaction that had already taken place. Once good faith attaches, it's permanent and it insulates the purchaser from any future revelations. As the president inquired of respondent's expert in this case, Dr. Reyes, assume I buy a property in Colombia and there is no problem. Nothing turns out, I do a due diligence that you would consider sufficient. And 10 years later, I learned that a relative of Escobar was involved in the initial at the origin of the property. Now, does this affect my property rights? Colombia's own expert was unequivocal. Absolutely not. The president further inquired, okay, if I want to resell the property in the year thereafter, so the new circumstances arisen and I want to sell my property, and now it is known that there was an an illicit circumstance, would I be able to sell the property to somebody else? Would that somebody else be a good faith purchaser? Because he would know, wouldn't he? Probably he would know of the illicit origin. Dr. Reyes again was unequivocal. Yes, you can sell it. Claimants were entitled to rely on the diligence that they had done even after Ivan Lopez surfaced. And I want to, I know the court is already familiar with this. I'm not going to go over it in detail. Mr. Seda was cleared by an OFAC inquiry into his Colombian businesses. Now, again, as set forth in Mr. Seda's original witness statement, on 14th of February, 2018, agents from the FBI appeared at my home in the United States while I was away and questioned the mother of my children, as well as our secretary and housekeeper. They said they were conducting a search based on a newly published list by OFAC. To the FBI later, they informed me that the Fiscalia had sent them an alert that I was related to various Colombian drug traffickers listed in the new OFAC lists. OFAC officials thereafter sent me several requests for information. He had to hire attorneys and a team from Kroll at his own expense to respond to OFAC's detailed requests. OFAC took no action. And again, Mr. Seda was told that this inquiry was prompted by a tip from Colombian authorities. Nothing happened as a result of that inquiry. OFAC looked at the records for all of Mr. Seda's Colombian businesses, not just the Meritage, Luxay, everything. To hide on these topics. He is happy to answer any questions that the tribunal might have. And we made that offer during the closings when Colombia raised many of these allegations for the first time. And Mr. Malou said, Mr. Seda has asked for the opportunity to explain to the tribunal the misunderstanding around Zing. And Ms. Bonifatemini said she has to object because if he makes a further statement, then we will have to cross-examine him and this will be never ending. In sum, the new evidence has no effect on Newport's good faith. And as my colleague, Mr. Malou, has already explained, that is the key issue in this case. The asset forfeiture law, the essential security interests invoked by Colombia here must carve out protections for good faith third parties. It cannot affect good faith third parties. I turn it back over to my colleague, Mr. Malou, unless the tribunal has questions.
I don't think we have questions at this point of time, so we would ask Mr. Malou to proceed.
Thank you, Mr. President. The final part of our presentation will be on how we believe the new evidence does not undermine claimants' new claims, but in fact bolsters it. And I'll deal with the first half of that in the next 5 to 7 minutes at the hearing. And so one of the things you were told was, well, actually, we're looking into the sister property, and it's at the initial stage of the asset forfeiture proceeding. Well, it's been a year and nothing has happened. This was a common theme. A year ago, you heard a lot of things that, oh, we're looking into it. This is going to happen. Just come back to us a year from now. It's too soon. Nothing in the last year. If we go to slide 89. In fact, you recall, members of the tribunal, that not only does it not affect the good faith third-party status, but there was no inquiry into the good faith third-party status at the outset. When I cross-examined Mr. Caro about that, he confirmed that there was no inquiry into Newport's good faith status at the time that they were doing any investigation, because he said, we didn't need to look into them. We just needed to look into Corfi Colombiana because they were, Newport was tied to Corfi Colombiana, but he confirmed that there was no finding with respect to Newport at all. And likewise, we know, because it was only in April 2022, that it was only recently that Newport was actually recognized as an affected third party. And so they've been sitting in limbo for 7 years. And at that time, we were told at the hearing, and a month after this decision in April 2022, that we'll find out in a year. We'll know in a year. When cross-examined, Mr. Caro, during that cross-examination, was asked by by Dr. Ponce, how long can we expect a final decision as with respect to Newport? When are their good faith status finally going to be reviewed and assessed? And he said, I would estimate 1 year. And in the closing submissions, several months later, you could see a little bit of a tentative answer from Counsel for Colombia, because at that point it had already been 6 months and nothing had happened. And when asked from a timing perspective, what's happening in these proceedings by Mr. President, Counsel responded, I had been told 1 year. Whether that's really feasible, I don't know. According to Caro's testimony, it's 1 year. And in Colombia's opening, Ms. Bonafetemi said, well, the courts are making a determination as to whether Newport, which is now an affected party, whether it will be considered to be a good faith third party. And here we are a year later, and not one step, not an email setting dates has taken place. So quite clearly, all over the last year, what have we learned? We've learned that indeed Newport's due process rights have been violated. There has been an FET breach, and nothing is going to change. This property is gone. It's not coming back. Newport's good faith status is not going to be assessed. Annie?
Just in conclusion, I know that this tribunal is fully familiar with the red flags analysis. It's often impossible to get direct evidence of corruption. So I won't dwell on this, but Mr. Seda's unrebutted testimony that he was approached by individuals claiming to be from the Attorney General's office even before asset forfeiture proceedings were begun, unrebutted by Colombia. They conceded that they do not know whether there was a shakedown against Mr. Seda. Documentary evidence, communications, documenting the extortionate demands made to Mr. Seda by Mr. Lopez, whose attorneys claim to be able to influence the asset forfeiture proceedings, unrebutted. Newspapers reporting corruption of prosecutors involved in the seizure of the Meritage project. Numerous investigations of these prosecutors. is arrested and charged with an extortion scheme. So Ms. Noguera, to remind the tribunal, was the head of the asset forfeiture unit following Ms. Malagón. According to the press and the charges against her, she, along with drug lord Carlos Ramon Zapata and one officer and two non-commissioned officers of the National Police, located people with pending proceedings at the Asset Attorney General's office, identified them, and extorted them for large sums of money in exchange for various forms of favorable treatment. The meetings arranged by Carlos Ramon Zapata had another purpose and modus operandi. To give it the appearance of legality, they arranged for two prosecutors, Daniel Hernandez and Daniel Cardona, to receive the former drug lord's complaints, claims an investigator in the case. Again, this is exactly what they told Mr. Seda. We want Mr. Cardona and Mr. Hernandez to take your statement. Now, naturally, as any, rational person would, Mr. Seda wanted his attorney present at those meetings. I attended one of those meetings. I met Mr. Cardona. They assured us that they wanted to hear Angel's testimony, that they wanted to take a statement from him. They assured us that they wanted to help us resolve the case. Importantly, Colombian officials were aware of these meetings at the time they were happening. At Ms. Noguera's urging, Mr. Seda reached out the blazing red flags, which indicate that Mr. Seda was approached during the course of this very arbitration and what appears to be yet another extortion scheme. If I hadn't attended those meetings, if Mr. Seda hadn't recorded it, goodness knows what would have happened. Would there have been an extortion demand? Given Ms. Noguera's pattern, we can only assume that there would have been. So again, there are ample red flags here. The tribunal is fully empowered and entitled to connect the dots here. But I want to note also that this demonstrates Colombia's violation of its obligation to accord fair and equitable treatment to the claimants under Article 10.5. If the asset forfeiture proceeding can be resolved with a bribe, if an asset seizure is undertaken for a corrupt purpose and can be resolved with a bribe, then there can be no essential security interest related to that proceeding. A corrupt purpose cannot correspond to an essential security interest. And with that, we will conclude.
Mr. President, if I may, I did not wish to interrupt Ms. Champion while she was arguing, but we do take issue on record that 3 times she, and she knows better, she is providing testimony based on her attendance of a meeting. She's not a witness here, she's counsel. So we take issue with that, and I want just to put that on record. Thank you.
Yes, thank you. It's being put on record. Do my 2 colleagues have questions to claimant's counsel at this point of time?
I don't have any, Mr. President.
Thank you.
I don't want to have any questions. I do have a request, though. The presentation that was sent to us by email, roughly around slide 50, the bottom of all the slides is cut off. So we lose all the references to the record. So if the claimants can redo it and resend the PDF with the slides complete, because otherwise some of them on the margins have the references, but the bottom blue footer with all the references is lost as of slide 50 or thereabouts. So
yeah, we'll address that. We'll address that right away. Apologies for that.
Yeah, and if you can resend it, I mean, just now, so that we can have it and we can continue to work on it. So don't wait until the hearing is over. That's my request. Thank you.
Understood.
Thank you. Same here. And we will now have a break of 15 minutes.
Mr. President, may we just have the time count, just so that we know where we stand?
Yes, I think there was 5 or 10 minutes in excess. Sarah, was that the case?
Yes, claimants have 23 minutes left.
Okay, so 7 minutes over budget.
Thank you.
All right, so let's have a 15-minute break, meaning that we will resume at 37. Right? Thank you very much.
Mr. President, oh, you were on mute, I believe.
Okay, can you hear me now?
Yes, we can.
Okay, so Sarah, I presume we're all back, and we will now give the floor to respondent, Mrs. Bani Fatemi.
Mr. President, if I may, before hand, just so I'm not interrupting Ms. Bani Fatemi, just our quick scan of the slides that were sent, it does appear that there are some exhibits that the tribunal excluded from the record that did not allow inclusion onto the record that are nonetheless in the slide deck that respondent has sent. And we would ask that that be removed. I think it is highly prejudicial to be addressing exhibits that are not in the record and that the tribunal expressly did not permit into the record in the slides.
Can we hear the respondent on this?
Thank you, Mr. President. I fail to see what Mr. Mulu is referring to. We only refer to existing evidence on the record. If he has any issues, you can.
At slide 30, for example, and I
just bear with us, Mr. Mulu. We will explain our case and the tribunal will decide.
Mr. President, I'm in your hands, but it does include a quote from an excluded exhibit.
The quote, Mr. President, is from our post-closing submission, which is on the record by definition.
Well, it's difficult for us to put a view on this. It's a slide with at least 3 quotes from various sources, and so what I would suggest is that when we come to this slide, Mr. Mulu, please let us know precisely what you're objecting against, and then we will hear the response.
If I may, Mr. President, I'd rather not be interrupted in our submission because I on purpose did not interrupt at any point in time, even though Ms. Champion 3 times actually put on record testimony, whether, despite the fact that she's not a witness. And I also want to put on record, since we're on complaints, I want to put on record that the claimants went well beyond the scope of today's hearing, which was essentially to discuss essential security, the tribunal's questions, and the reports. And they have essentially re-argued their entire case. So we did not say anything to just not interrupt, but I have to put that on record because what we heard was a scope that is well beyond what the tribunal allowed for today. So this is my complaint to the tribunal. As regards slide 30, I want to just say it right away. There is a reference to our post-closing submission on the right side. And that is our post-closing submission. This is what is on the record.
It's very easy to address, but we didn't because that specific quote is from a document that is excluded from the record. I don't think it's fair to say we've quoted a document that is excluded from the record in our post-hearing submission, and therefore we can just cite to our post-hearing submission, which quotes the document that is excluded from the record. I think an exclusion from the record means excluding from the post-hearing submissions as well. That document and that reference is not on the record. And I don't think they should be able to, through the back door, include quotes like this. I don't know if there's others. This is just the only one that this is the first one that we came by. It's clear that that is from a document that is not on the record.
And again, Mr. President, this is our post-closing submission. It's there, it's on the record. We are taking issue with the fact as a matter of due process. So there is a whole issue of due process here, but as far as we're concerned, this is just a citation from our post-closing submission.
Well, I think we should proceed. I mean, I read it, of course, it's your post-closing submission here, but there's a quote in paragraph 117, and I think the issue is about the source of this quote, if I understand correctly, no?
Yes, Mr. President, and that was what was put before the tribunal in our post-closing submission, and that stands. It is our closing submission. That's not excluded from the record. And I hope the tribunal will not now exclude our post-closing submission from the record. That's one thing. The second thing is that Mr. Mulu is taking issue, but they also in their opening earlier referred to documents that are not on record. For example, slide 105, I understand, is referring to documents and information that is not on the record. So they're quite ill-placed to come and complain about documents and information that's not on record when they do the same themselves. And here, all we're doing is referring to our own written submissions. That's all we're doing.
Okay. It is put on record. I understand now that the quote here has been put in the post-closing submission. So if you want to complain, Mr. Mulu, the complaint goes against that post-closing submission rather than to the slide, because the slide just reproduces what has been put in the post-closing submission. And we have it on record now.
Okay, Mr. President, and just for my own clarification, my assumption was that if a document was not permitted, because they cited a number of documents in their post-closing submissions that were excluded by the tribunal from the record, I would assume that that would mean that by excluding a document from the record, they can't through the back door just quote it in their post-hearing submission and include it in that way in the record then. So by excluding something from the record, it means stricken from the record, including any quotes in, but those are my submissions. I'll leave it with you, Mr. President.
Okay, we understand the quote comes from the exhibit R319, and that document indeed has been excluded from the record.
Correct.
But what we're shown here is the post-closing submission. So it's not that the slides introduce something new. They just copy what has been said in the post-closing submission, and the understanding is that that document, if that is the source of this quotation, has been excluded from the record. That is correct. All right, let's now proceed, please.
Thank you, Mr. President. It is my honor and privilege to make a presentation on behalf of Colombia. Before we do that, I would like to leave the floor to Ms. Ana Maria Ordóñez, the director of ANGE, who would like to say a few words.
Thank you, yes. Mr. President, members of the tribunal, good morning and good afternoon to everyone. As the tribunal may recall, at the start of the closing hearing in October 2022, I explained the unprecedented efforts made by the Colombian state to make available all it needs to do is recognize the exceptional circumstances of this case, which raises Colombia's essential security interests. The consequence of this situation is that the tribunal shall refrain from intervening in such delicate matter. First of all, it is generally accepted that investment tribunals are not to act as appeal courts with respect to the decisions of domestic courts, let alone interfere with the work of the courts in an ongoing case. In this case, the very measure in dispute is the asset forfeiture proceedings against the meritage law. Although the domestic regime on asset forfeited should be clear to everyone at this late stage of the proceedings, I should limit myself to recall the teachings of Professor Reyes, who clearly explained the progressive character of the asset forfeiture proceeding, including the high standards of proof required to progress from one stage to the other. Indeed, the asset forfeiture proceedings project is ongoing, and the Colombian state has progressively obtained evidence of the complex and dangerous structure underlying the Meritage project. Currently, our courts are deciding an annulment request of the proceedings filed by Newport in May 2022. In particular, the evidence obtained and which has been made available to the tribunal shows that the Meritage case involves Colombia's essential security interests. It is on this basis that on 16 February 2022, acting in good faith, Colombia invoked the essential security exception in Article 22B of the TPA. As Colombia has shown and the United States has confirmed, Once the essential security exception in Article 22(2)(b) of the TPA is invoked, the tribunal is deprived of the power to adjudicate the dispute. This has been purposefully negotiated by the contracting parties, and it remains their understanding now. Conversely, the claimant's position poses a serious threat to the very basis and limits of Colombia's consent and to its sovereignty. We respectfully requested this tribunal, whose power to adjudicate is based on the TPA, not to turn a blind eye to the contracting parties' agreement and its limitation, as reflected in Article 22(2)(b) of the TPA. There should be no serious concern that we invoke the essential security exception in absolute good faith, once the fundamental factual basis for such invocation were made available. Importantly, out of 21 investment arbitrations filed against Colombia since 2016, this is the first time we invoke the essential security exception. Mr. President, members of the tribunal, as a representative of the state of Colombia, I am here to reiterate Colombia's commitment to fight against organized crime and money laundering. As a member of the international community, however, Colombia requires the assistance of other international actors, including this arbitral tribunal, to carry out this important fight. Upholding the claimant's claims would not only cast doubts on one of the most valuable instruments in the fight against organized crime, the asset forfeiture proceedings, and instrumentalize the investment protection system to perfect money laundering, but ultimately undermine Colombia's sovereignty. We trust this tribunal not to uphold this. Thank you for your attention.
Mr. President, I think you're on mute.
Yes, thank you very much. We will now hear Mrs. Bani Fatimi.
Thank you, Mr. President. So moving to the next slide on our line that I will address. The first point I would like to address, of course, is the US treaty practice and the long-standing treaty practice, which confirms that Colombia's invocation of Article 22(2)(b) of the TPA is non-justiciable and that therefore the tribunal lacks the power to adjudicate it. It was really interesting that Mr. Molu didn't address the long-standing practice of the US. I should note that the US is the home state of the claimants. If anything, it's more than relevant to what the tribunal will have to decide. And the US actually went through the pains of providing a number of treaties to show that practice. And that's what I want to address now. So I'm at slide 46. This is a very simple slide, really. It shows you there's two stages. There's the stage of the US treaty practice where there was a reference to the security exception as a self-judging matter. Simply, it was implicit. Up until the decisions by the ICJ in the Nicaragua and the oil platform cases, where the court, I will come back to this, decided that because the word "it considers" is not there, it means that it's not self-judging somehow. So after that, you have an explicit language that was included in the US treaty practice from the years 2000s onwards. So slide 47, you see that this is the old version, the implicit version of the US treaty practice. You have examples given. So on top, you have the two treaties that were the basis of the ICJ decisions in the Nicaragua and the Iran platform cases. You see, it just refers to necessary, the measures that are necessary to fulfill the obligations of a party. And you have the same thing in the US-Argentina BIT of 1991, which also refers to measures necessary. So this does not mean that in the US treaty practice, this was not self-judging. It was always, and it has always been self-judging in the US treaty practice, simply it was implicit. And then you see on next slide what happened in the ICJ case. On the left side, you have the Nicaragua case where the court said, and said that it had jurisdiction to determine whether the measures fall within the exception because, a contrario, from the fact that the text of Article 21 of the treaty does not employ the wording and you see that further down, it considers necessary for the protection of essential security interests. So to the extent that the ICJ says, I'm going to determine whether this is properly invoked because I don't see the word it considers, therefore it's not self-judging. And having confirmed that, you see on the right side in the oil platforms case that, the ICJ said there's no reason to vary its conclusions from the Nicaragua case, then it shows that the ICJ wanted to see the word it considers in order to say, I recognize that this is self-judging. So then you see what happens. That's on slide 49. That's the US model BIT of 2004. You see that the US introduces the word it considers, measures that it considers necessary for the fulfillment of its obligations, etc. So this comes after the ICJ's decisions and makes explicit and quite clear that this provision is self-judging, and therefore it's enough for the state to say that it considers necessary for the measures to be excluded from any consideration by any tribunal. Now, next slide you see, and that goes to the efforts made by the US at your request to provide a number of treaties. First of all, there's a number of FTAs that the US provided. You see that the wording of security exceptions in FTAs concluded between the US and 18 other countries is very similar to the wording of Article 22(2)(b) of the TPA. And you have that, of course, in the submission by the US. You see also that there's 4 BITs, and you have the list here: Mozambique, Bahrain, Uruguay, and Rwanda, where again, you had very similarly worded provisions to the US Colombia BITs. And all of those, of course, come after the ICJ decisions and after the model BITs were adopted. This actually you see on the next slide. These are the 2 model BITs of the US of 2004 and 2012, which contain explicit self-judging language it considers necessary. And again, you see this all came after the ICJ decisions. Mr. Mulu likes to go back to the ICJ decisions. What you're looking at is language that was adopted after those decisions and consistent language adopted after those decisions, including the models adopted by the US. I should note, and you see here, there's a note at the bottom of the page that there is no footnote in the US model BITs. You have the provision which says it considers necessary. Now, if you go to page 15, this is from the US's oral submission of May 2022. And you recall, and we heard the same thing, frankly, today. Once, I quote, once a state party to the TPA raises the exception, its invocation is non-justiciable. And here they refer to footnote 2, and they say that it's prefaced by the phrase "for greater certainty," I quote, which in US practice confirms that the self-judging nature and non-justiciability of the essential security interest exception is inherent in the language of the exception itself. In other words, the phrase "for greater certainty" signals that the text it introduces reflects the understanding of the United States and the other treaty party or parties of what the provisions of the agreement would mean. So this is clear. It's not only an intention and the practice of the US, it's also intention of the other party or parties to the US. And my next, before I go actually to my next slide, maybe I should, if you bear with me, just to pause here, because we are talking about the concept of non-justiciability, to refer to a couple of comments that were made earlier. Mr. Mulu earlier, I think it was in relation to slide 27, said that we essentially have agreed that this tribunal should have the power to make a determination, and therefore it's not non-justiciable, because we somehow have said that Colombia has raised and has invoked the exception in good faith. That is, there's no contradiction here. It's simply a statement by Colombia and a confirmation by Colombia that it's not playing with this provision, that it has raised and it has invoked in quite good faith the exception that exists in 22(2)(b). The second point, Mr. Mulu again went back to the fact, and frankly, it's he says read the language. Yes, read the language. It says nowhere that you can determine the merits of the dispute once the exception has been invoked. And you heard earlier the US representative saying that precisely this is a derogation. The provision that you have in front of you is an exception. It's a derogation, which means that it excludes the entirety of the measures from the TPA obligations. It doesn't mean that you have the power to go and determine whether or not the obligations were fulfilled. It is excluding that there are obligations in the first place. This is what it says. And you have to read it as it says. So Mr. Mulu likes to go back to TPA Article 1026. He likes to argue restitution and compensation. He likes to go back to Ekoro, even though it's a completely wrongly decided decision. For that matter, if you go to CMS, CMS has the right approach. That's exhibit RL 168, and I quote from CMS. It's the same type of language. It says Article 11, which is also a type of derogation on security interest, is, I quote, a threshold requirement. If it applies, the substantive obligations under the treaty do not apply. This is what you heard earlier from the US as well. Simply when the exception is invoked, the underlying obligations of the TPA do not apply, period. So you cannot say there's a breach, you cannot say whether there's compensation, and that's the end of the matter. And Ekoro, it doesn't help Mr. Mulu. Now, one final point here, and I will move on, is that the remedy exists only to the extent that the states have accepted to provide a remedy. The states here, both states have said there is an exception which can be invoked. Once it's invoked, it's self-judging. It renders the dispute and any determination non-justiciable, which is that it cannot be determined by the tribunal. There was a question from Dr. Ponce earlier about what remedy exists, and you heard the response from the US representation. Simply, again, what I want to add to that is that there is no absolute guarantee under international law that any investor or alleged investor can come and use international law, no matter what circumstances, no matter what the treaty says, and say, I have a right to compensation. Everything depends on what the treaty says. The remedy exists only to the extent that the states have accepted the remedy. In this case, the states have accepted the remedy only to the extent that they would not invoke the exception. If they do invoke the exception, the remedy is out, the obligation is out, simply, as simple as that. So I now move to back to the interpretation of the provision. So here, on the screen, you have what the US said, which is that it's the practice of the US and the other party. On my next slide, you see that the claimants are saying, well, no, it's not Colombia, it's just the US, on slide 55. You just did, this is US treaty practice. Colombia entered into other treaties and, you know, they don't have that, that's just US. I mean, that's wrong. Look at page 56, which shows that Colombia, of course, as a sovereign state, knows what it's doing. When it accepts a language, it accepts a language for a purpose. On the left side, you have the US-Colombia TPA of 2006, our treaty. It says specifically, it considers necessary for the protection of its own essential security interest. It says specifically in footnote 2 that for greater certainty, if a party invokes Article 22.2, the tribunal or panel shall find that the exception applies. This is what both parties said. This is what you see the US said, both parties said. When Colombia entered into the BIT with China, they said something completely different. They said there's an exception for public order and including measures to protect the essential security interests. And then you see that there's a footnote that says for greater certainty, nothing shall be construed to limit the review by an arbitral tribunal of a matter when such exception is invoked. So Colombia knows what it's doing. When Colombia wants a tribunal to review the invocation of an exception, it says so. When Colombia does not want a tribunal to review the invocation of an exception, it says so, just like the US. And here you have a complete understanding of both states of what exactly you have before you. Fourth point that, and you heard the US representative earlier today, about that here you are faced with an authentic interpretation of the provision, which is binding on this tribunal. So you see that on the left side, you have Colombia's position, on the right side, the oral submission of last year, but today we heard the same thing. You see that Colombia in its rejoinder referred to non-justiciability, the same thing in May by the US. You see that Colombia talked about a self-judging clause. The US said the same thing. It's not surprising, frankly, because if you look at the travaux préparatoires, they say the same thing and it's all there. And you see that in both oral submissions of both states last year, there was a reference to the Vienna Convention on the Law of Treaties, Article 31.3. We relied specifically on provision A of 31.3. And actually, it's on next slide, if it can be of help. So, and today you heard the US saying, regardless of how you look at it, either it is a subsequent agreement under A, or it is a subsequent practice under B, it is the same thing. You are bound and you shall take into account the what the US referred to as concordant interpretation and what both the US and Colombia are referring to as authoritative interpretation before this tribunal. And we say it is a subsequent agreement between the parties. But again, you had that also during the travaux préparatoires. Throughout, the parties, both parties have taken the same position. So what we say is that the tribunal is bound by this concordant and authoritative interpretation, that to Article 22.2 is a self-judging provision, and it means simply that the invocation is non-justiciable, and the tribunal does not have the power to make a determination. Moving to my next point, and this is also, of course, in the alternative, you may recall, we discussed that last year. In the alternative, if you believe that you do have the power to make a determination, we say you do not have because it's not justiciable. Nobody, in fact, can make a determination. Only the states can, and each state invoking the exception makes a determination for itself. Even assuming that you do not agree, you will still say you do not have the jurisdiction to make that determination. I will not expand on this. We argued this at length last year. This is just a reminder of what we discussed last year, and I respectfully refer the tribunal to our submission last year at the closing, where we took each of the interpretation means of the Vienna Convention: ordinary meaning, context, object and purpose, effet utile principle, authentic interpretation, which I just discussed, and the travaux préparatoires. I will, and you have, of course, each time a reference to our PHB on exactly what we discussed there, and also a reference to our closing. The one point I do want to discuss is the new point that is made by the claimants, and you see the allegation here, which is that essentially the preamble, looking at the preamble, and they tried to create some confusion here. So I quote, the US submission makes clear that Article 22.2b is the typical provision that the US includes in its investment treaties with countries all over the world, the majority of which are not afflicted by significant drug trafficking. The inclusion of this provision, the provision in the US-Colombia TPA, does not appear to carry with it an inherent policy objective contrary to Colombia's suggestion. So I have a number of points to make here. The first you see on this slide is that there's a misrepresentation by the claimants of Colombia's position. It is not the inclusion of the explicit self-judging language in Article 22.2 that carries a policy objective. The policy objective is reflected in the preamble of the TPA, as I will show now, in fact. You see on slide 63. And interestingly, you look at the travaux préparatoires and what the state said, and in this case is the press releases of the US trade representative at the time. There was a recognition by the US that this is about, and the policy objective of the states, both US and Colombia, is to fight against narco-trafficking terrorists. You see the 23 March 2004, Colombia's courageous fight against narco-trafficking terrorists that threaten democracy and regional stability can be assisted by promoting economic development, etc. After the negotiation, same thing. You see again the US saying an agreement with Colombia is an essential component of our regional strategy to advance free trade within our hemisphere, combat narco-trafficking. This is part of the policy objective of the two states. And you see the preamble itself, it says, generate opportunities for sustainable economic alternatives to drug crop production. So the preamble essentially shows that the contracting parties intended the preamble to carry the objective of fighting against drugs. So this is the policy. The policy reflected in the preamble, and that's as simple as that. And if you compare the treaties that we have with all of the other treaties provided by the US, you see that there's this preamble is reflected in two treaties, our treaty with Colombia and the treaty with Peru. And you see that in the preamble in the US-Peru TPA, there's reference to generating opportunities for sustainable economic alternatives to drug crop production. So essentially, the US-Colombia TPA was precisely conceived to assist the contracting states to fight against drug trafficking, and the tribunal has to take that objective into account when it looks at its mandate in this case. My third point, and that's a further alternative, if you were to find that you have not only the power to make a determination, but the jurisdiction to make a determination, and actually you were going to assess the invocation by Colombia of this essential security interest, we say that the respondent has not, cannot have breached its obligations under the TPA. Here I would like to address briefly the tribunal questions, the three of them. So the first question, number one, what is the legislative purpose of the Colombian asset forfeiture law? You have on the left side the provision from the Constitution, Article 34, which refers to the prohibition of confiscation with the exception of what you have before you, which is asset forfeiture. I quote, assets acquired by illegal means to the detriment of the treasury or resulting in severe deterioration of social morals shall be the subject to forfeiture by judicial order. This is what we're talking about. You have on the right side a couple of decisions, important decisions by the Constitutional Court of Colombia, which explains the context for the asset forfeiture law. And you see that, again, historically, this came about, and I think that there's no disagreement between the parties, as a consequence, I quote from the court here, a consequence of the serious proliferation of illicit conduct of very diverse origin, especially drug trafficking, and the high degree of corruption that had taken hold of Colombian society. Asset forfeiture arose as society's reaction against organized crime. And you see the second decision of 2016, again, it refers to the law's main purpose being to combat drug trafficking and illicit enrichment. This was confirmed on my next slide by Professor Reyes, the expert for Colombia. On your own time, you can refer to that, but if you look at the right side of the page, you see that it's important to keep in mind that all of this was about solving the most complicated problems existing in the fight against drug trafficking, because these things take time, right? And because the assets of the drug traffickers could only be seized after they had been criminally convicted for their crimes, there was this policy of allowing criminal proceedings, which are very long, to not allow the drug traffickers to benefit from that. And so this gave, Professor Reyes says, drug traffickers time to create new mechanisms to conceal their assets. This is the rationale, this is the reason, the raison d'etre of the asset forfeiture law, as explained by Professor Reyes. The experts don't disagree. Mr. Mulu actually referred to their own expert here. You have excerpts from both experts who refer to asset forfeiture proceedings allowing to attack illegal activities such as drug trafficking. You see that from Professor Medellin, and Mr. Wilson Martinez said the same thing, a tool to fight organized crime, go after the proceeds that fund criminal organizations. Question 2, what is the precise essential security interest that the respondent is invoking? Mr. Molu pretends not to know what we're saying, and he vaguely referred to a number of different excerpts. It's very clear. Rejoinder, respondent's rejoinder, you have it here. I quote, the position of the Republic of Colombia in this arbitration is that it seeks, through asset forfeiture proceedings, to fight against organized crime, money laundering, and drug trafficking. This is the essential security interest evoked by Colombia. Simple. Question 3, to what extent the legislative purpose and the essential security interest are similar? There's of course an overlap. You see that the fight against organized crime, money laundering, and drug trafficking is the same thing as the rationale for the law, which is to protect the social morals and fight drug trafficking, etc. So just one word, that there is an overlap here. In this case, the law itself is broader. As you may recall from Article 34 of the Constitution, it is about the severe deterioration of social morals and detriment to the treasury. So there may be situations where asset forfeiture may occur, which are not related to drug trafficking, but the main purpose of the law is drug trafficking, as you've seen from the history of the asset forfeiture law. One point here, I think that Mr. Moulou, in relation to slide 19, referred to our invocation of the law being the essential security interest. No, the essential security interest that we invoke is, as we have phrased, which you see on this slide, is that through the asset forfeiture proceedings, we are fighting against organized crime, money laundering, and drug trafficking. And that is, again, quite simple. Now, moving to my next point. I'm sorry, I'm trying to get rid of the echo that I have. Thank you. So my next point is, assuming that you have the power to assess Colombia's invocation of Article 22(2)(b), the standard that you have to apply is a prima facie test that we fulfill. So the first point is that if you look at the features of Article 22(2), they're all present here. There is first to have to be measures that are applied, and that's what we have. We have applied measures as part of the asset forfeiture proceedings. These are measures that are considered necessary. So Colombia considers them necessary. And these are for the benefit, for the protection of essential security interests. And as you see, we have said, and I will come back to this, these measures are plausibly expected to protect Colombia's essential security interests. And in relation to the footnote, once the exception has been invoked, the tribunal is bound by the state's determination that these indeed are for purposes of the essential security interests. And that this determination, you have to defer, and tribunals have to, at some point in time, when it's a matter of sovereignty, especially when it goes to such important aspects as criminal investigation and criminal liability and fight against corruption and fight against money laundering and fight against organized crime, there has to be a point where tribunals have to defer to the determination by state of what is necessary for the protection of that interest. And that's exactly what you see in footnote 2, which is that once it's invoked, the tribunal shall find that the exception applies. Here you have the resolution 125 of 2016 by the Attorney General's office, which essentially started and initiated the proceedings. You see there was reference to priority of the investigation. It involves a criminal organization related to Envigado cartel. So at the time when the proceedings were initiated, the involvement of the Oficina in the chain of ownership appeared to be historic. Essentially, Ivan Lopez, there was some trace of the cartel appearing in the chain of ownership, and that was part of the investigation. You see on the next slide that the initiation is based on Article 25 of the Asset Forfeiture Law, which refers to a cost, I quote from Article 25, a cost-benefit analysis of the forfeiture of the assets, as well as the risk which such assets create for national security. So the resolution relied on this provision and on the national security risk that the historic involvement of the Oficina with the Meritage lot could entail to Colombia. That was the initiation of the proceedings. And you see on the next, Superior Court of Bogota in April 2022 essentially summarized the evidence that was available to the Attorney General's office at the time that the proceedings were initiated, essentially showing the historic involvement of the Oficina. Look at the box here, which we have highlighted, I quote, "It was established that the Envigado cartel coerced the owners of plots located over a large range of the metropolitan area of Medellin to place them in the responsibility of agents of an undisclosed principal, executing real estate project of broad scope with an appearance of legality, which constituted a method of money laundering. For these reasons, the initiation of investigations to clarify the origin and acquisition of the property was ordered." So this is the initiation. This is what Colombia, the prosecution, the Attorney General's office started looking at the origin and acquisition of the property. The fact that essential security is a narrow concept, and this is from the WTO decision. Mr. Mulu likes this decision. It does refer to, well, WTO, as you know, is a different animal. It has a different type of provision because it has a list, as you know. I'm not going to go back to that. And you see that here it says that the essential security interest essentially is the core, is the very narrow core of what is the interest of the state. And it says it depends on the particular situation and perceptions of the state and can be expected to vary with changing circumstances. For these reasons, it is left in general to every member to define what it considers to be essential security interests. And of course, all of this is in the alternative. We say that you do not have the power or jurisdiction to make that determination, of course, but even assuming that you do, this is what you have to look at. It's the narrow, the core essential security interests as determined by Colombia. And you remember also the footnote of the treaty, which says that once it's invoked, you're bound by the determination by Colombia. This is from the WTO Russia case, which is where you see the standard, the minimum requirement of plausibility in relation to the proffered essential security interest, i.e. that they're not implausible as measures protective of these interests. And as I've shown you, this is, more than plausible that what Colombia is doing is indeed to stop the bleeding, stop the money laundering cycle, and stop drug traffickers from getting money through an arbitration here. For your own time, this is slides 87 and 88 is really the summary of our arguments with the fact that we have raised the illegality objection in relation to money laundering. Yes, we have. It's your duty, and this is a reference to one example only, Infinito Gold, which is that, and that's Rule 41.2 of the ICSID rules. You have the duty to raise ex officio any at any stage of the proceeding, anything that goes to jurisdiction. Illegality of the investment is one such objection. We have raised it, and you have, of course, to make a determination. Mr. Mulu himself, when he writes articles, agrees that international public policy and fraud should prevent a claim from proceeding. He talks about admissibility in his article, by the way. We say it's jurisdiction, but nevertheless, the claim should not proceed as he accepts in his own writings. And of course, what we say is that because the investment is tainted by illegality and money laundering, you do not have jurisdiction overall. I will not go through that. That's for your own time. And I thank you very much for your patience. That completes our submission.
Thank you very much. I turn to my two colleagues. Do they have questions at this moment?
I have just a quick question to Professor Bani Fatemi, Mr. President.
Yes, please go ahead.
Professor Bani Fatemi, tying up to what you just said, and again making a hypothetical, if a state were to wait all the way through an arbitration to see how things are going and then raise at the last minute an essential security defense, you are saying, aren't you, that the arbitral tribunal would have to defer anyway, and the only answer would be costs?
Our answer is very simple indeed. The very wording of the essential security exception, as agreed by the states, is that once it's invoked, it's self-judging, and a tribunal does not have the power to make a determination as to whether or not it was raised in good faith. So that's the end of the matter, and it should be the end of the matter. And you have to consider that rights, including rights for investors, exist only to the extent that states accept to give those rights. If states in a treaty say, we are going to exclude any obligation when we have, or when we're faced with an essential security as we deem it, that is the limit of the treaty, and that is the limit of the protection of investors. It's as simple as that. So the answer is yes.
Yes, I think I've gathered that by that, but you haven't by now, but you haven't really answered my question. My question was assuming that a state wants to see how things work out, and at the last minute raises the essential security exception. The only thing an arbitral tribunal can do is adjudicate costs, award costs, because this was raised at the last minute.
The thing that the tribunal has to do is to take note of what the state is saying in relation to its essential security interest.
I understand that, but there's no other answer than costs.
What it may well be that it's in relation to part of the factual matrix that's before the tribunal. I do not know in what circumstances essential security interest can be raised. In this case, what we're saying is that in this case, the invocation covers the entirety of the dispute, because this is about a property and an asset that is the object of asset for future proceedings in Colombia in relation to narco trafficking. And the essential security that we're pursuing is fight against corruption, fight against narco traffic, fight against money laundering.
Does it make a difference when it's raised?
No, it doesn't, and it shouldn't. It's the state's
in terms of costs?
It's the state's discretion. If a state on the treaty the states have agreed to have that right and to exclude the application of the treaty. So that's the limit of the treaty. Either you do not have such a provision, in which case you do not have this problem, or you have a provision such as the one that you have in the Colombia-China BIT, where the party said specifically, this does not exclude court review. In that case, the tribunal has the power to make a determination, or you have what you have here, which is self-judging. And yes, the tribunal is bound by what the states are saying.
Sorry for interrupting you again, but I think I've understood that. My question is specifically with regard to the costs of the arbitration. Let's assume an essential security exception is raised at the very beginning, or in the middle, or at the end of the arbitration. Is there an impact in the way an arbitral tribunal should award costs?
To the extent that the tribunal is faced with a self-judging provision.
But with a self-judging provision that can be invoked early, in the middle, or at the end of a case?
Well, first of all, just to be clear, we do not accept that we raised it early or late. We raised it when the matter became clear, that is in relation to narco traffickers being the beneficial owners of the property that is before this tribunal, to be very clear. And we have said, and that's not contradictory, that we have said that this was raised in good faith. That's to give reassurance to this tribunal.
What do you mean it's not contradictory? You mean it's not contradicted, or is it?
It's not contradictory with the position that this is self-judging.
Okay.
So now, it depends. It's if a state determines at the end of the process that there is a national security interest and raises at that time, how is it a matter of cost? It's a matter of the tribunal simply giving effect to the state's determination that this is an essential security interest.
Okay, but the fact that the security interest exception is raised does not take away the arbitral tribunal's power to adjudicate costs in the arbitration, right?
The general power to give costs remains.
In making this assessment, an arbitral tribunal, though in your view, not authorized to adjudicate whether or not the exception was raised properly, could still say, I think it should have been raised earlier, and therefore I'm awarding costs.
That assumes that the tribunal, in fact, engages in the assessment of the manner in which the invocation occurred.
Not the manner, the timing.
It's the same. The circumstances in which the exception was invoked, again, it's self-judging. So what we say, and what the US has said earlier today, you have heard, it's self-judging. It's a discretion of the state to make its own
No, I
determination.
understand.
By
We've
nature,
understood your position.
by its very
Yes.
nature, it's essential security. So nobody is in a better place than the state to determine that it is essential security. So whether it's early or in the middle or the end doesn't make any difference, because that discretion should be untouched. So there should not be any costs related to that, because by definition, if you accept that it's self-judging, there should not be any determination, including as to cost, in relation to the invocation and the circumstances of the invocation. Costs kick in only if you are in the alternative of the tribunal having the power to make an assessment of the invocation and how and when it was made. In that case, the tribunal has the power of the cost. Otherwise, it should defer to the state and its invocation of its ancestral security interest.
You will agree with me, won't you, that this effectively means that if there is an essential security exception or defense in a treaty, the investor is hands and feet bound. His only chance to obtain an award is purely in the hands of the host state, which can make its own decision as to whether or not it's going to raise that exception, invoke that exception. There's no protection for an investor who faces who files a claim based on a treaty in which there is a provision allowing the state to raise the essential security exception.
That is why I said earlier that there's no absolute right of an alleged investor.
Well,
The rights exist only to the extent of what the states have accepted. When there is an essential security exception, the states have accepted obligations with the possibility that in the event of an essential security interest situation, they may exclude the obligations. So because this is a complete derogation to the application of the treaty, there is no right for the investor. And that's a risk that the investor takes. Again, the right exists only insofar as the states have accepted that right to exist. If you do not have that provision, there's a broader protection for the investor. If you do have that protection, it's only to the extent of that.
The provision, yeah.
The essential security provision, yes.
Thank you very much.
Thank you, Dr. Ponce.
Mr. Malou, you will, of course, have the opportunity to comment on this exchange of arguments and questions. We will now have another break of 15 minutes before we have the break.
I do have a question, Mr.
Okay.
President, if I may.
Yeah, please go ahead. I'm sorry.
Thank you. Ms. Benefantemi, Mr. Molu made the point earlier today that Colombia in its rejoinder accepted that the standard of review was good faith. And Colombia indeed say in its rejoinder, I think Mr. Molu referred to a different paragraph of the respondent's rejoinder, or a couple of paragraphs. But at paragraph 43, the respondent did say expressly, it is the respondent's submission that the tribunal scope of review of Colombia's invocation of the exception is strictly circumscribed to an examination of whether the exception of essential security of Article 22.2b has been invoked in good faith by Colombia. Now, how the U.S. made the point earlier today that it was entirely non-justiciable, and that appears to have been the position that Colombia has also embraced. But how does one reconcile the respondent's submission in regard to the review in terms of good faith with the argument that it is entirely non-justiciable, and therefore there's really nothing for the tribunal to do? And you and arbitrator Ponce discussed this issue, but I think in the end, if I understood you correctly, you said not even as regard to costs. So how does one reconcile the position as expressed initially by the respondent to the position as has been expressed subsequently, including during the course of this hearing?
I think you're on mute, yes.
I'm sorry. I was saying that if you allow me, I would like to look at paragraph 43 of rejoinder, which I don't have in front of me, because I'm not sure that it was referred to correctly by Mr. Mulu. So would you allow me to come back to this after the break?
Yes, we do allow you. I think we need a break now. That was a question put to you. I myself have another question to both of you, which relates to the tribunal's questions number 1, 2, and 3. So if I understand correctly, you seem to agree that the protection purpose of the law and the content of the essential security interest that has been invoked is more or less identical. You spoke of overlap, but this is my understanding. Now, if this is so, could one consider that the state has concretized its security interest in the field of drug narcotic fighting through the law, and provided for an exception, namely the good faith acquisition? It is national law. You mentioned that this has nothing to do with international law. My question is that position really correct? Could one say, isn't that an exception to the exception? That is my question. You don't have to answer it now, but I think the question is clear. And the claimant has already, to some extent, commented on this question, but I just wanted to make it clearer, what is on my mind at least, to have your position as to this issue. Thank you very much.
Thank you.
May I make just a quick clarification, Mr. President, before we break?
Yes, certainly.
Thank you. Now, just to clarify my question. My question was my comment about what Mr. Molu said earlier today was just that he referred to it. My question was not about what he said earlier today. My question goes directly to what the respondent said in its rejoinder, which I quoted from verbatim. So that's my question. As a side comment, I said Mr. Malou raised this point earlier today. So worry about my question rather than how Mr. Malou may have phrased it or not. Thank you.
Thank you. That's understood.
All right. So let's have a break now. We can continue at 5 past, in our time it's 8:05, so 5 past the hour that applies to your time zone, if you agree. Thank you very much. Everybody back? Sarah?
Yes. The breakout rooms were closed, so everybody should be back in the
Yes.
room.
Sarah, would you kindly inform the parties about the time budget that is left?
Yes. I sent actually an email with the time is 13 minutes for respondent, 23 for claimants.
Yes, we will not run by the chess clock, but please have this in mind when making your final comments. So we invite the claimant first, Mr. Mulu.
Thank you, Mr. President. We do have a few slides that we're going to send through, but if you can indulge me, given the short amount of time, I will put them up on the screen unless you'd like to wait 30 seconds for them to come through by email.
We will wait.
Okay. It's been sent, so if the tribunal members can just let me know when it appears in their inbox. I know in particular, Professor Periscano-Diaz, you prefer to mark things up electronically, so just let me know once you've received it and I'll commence. Oh, I think Dr. Ponce, are you saying you received it? Okay. Professor
I
Periscano?
got it as well.
You got it?
Yes.
Okay. Okay, perfect. Thank you for your patience. You can take it down for now, but you know when to put it up. So, members of the tribunal, there are just a few points I'd like to raise in rebuttal. The first point I wanted to address were some of the due process issues that Professor Banafatemi raised at the outset. I think it is a little surprising, quite frankly, that respondent raises due process concerns when we are here discussing an essential security defense that was raised so late in the proceedings. And quite frankly, I think the tribunal has gone out of its way to allow respondent to raise this belated objection. You'll recall that when it was raised in 2022, after both of claimants' primary submissions in this arbitration had already been submitted, they characterized their defense as a jurisdictional defense. And you'll be well aware that ICSID Rule 41.1 says that jurisdictional defenses must be raised in the counter memorial. In procedural order number 9, the tribunal allowed respondent to raise this objection on a belated basis, accepting, for purposes of allowing it, that it was being raised as a jurisdictional objection because the tribunal said that it has discretion to deal with jurisdictional issues at any point in the proceedings. Again, showing that it was going out of its way to hear respondent's objection. Now, at that point, it was raised as a jurisdictional objection, but it has morphed into something that is not a jurisdictional objection. I think this is important because that's the basis on which they sought to have it admitted late into the proceeding. Now what they're saying is it's about justiciability, which is not about jurisdiction. Justiciability is this tribunal has jurisdiction, but it is not allowed to touch this particular issue. That's what justiciability goes to. It goes to admissibility, not to jurisdiction. That's a merits defense, and in procedural order number 1 at 14.2 and 14.3, it was made very clear that any defenses must be raised in the counter memorial, and Article 26 of the rules makes it clear that if something is late, it's late. Yet here we are in an entirely new phase, us having to deal with this new defense, and you have respondent saying that their due process rights have not been adhered to, despite the fact that we're in a third hearing because of this belated argument. They then complain that the transcripts that they sought to have admitted were not allowed by the tribunal. And they said, we gave them in advance to claimants, and they thought it would be helpful. They said that it would be helpful to them. Why did they object? Well, the reason we objected is because the first time we saw those transcripts were with the closing written submissions of respondents. They didn't give it to us before then. That's the first time we saw it. There were no more written submissions to be had in this proceeding, lest we continue this proceeding even longer than it already has gone for, with further written submissions. And so we objected on a procedural basis. We said, this is a brand new exhibit. We've never seen it. When we asked for this at the hearing, we were told, no, we're not going to give you transcripts. And then all of a sudden, with your post-closing submissions, you're introducing these transcripts and relying on them for the first time, making brand new arguments, including relying on the quote that they have now put in their slide deck before you today. Our objection was merely a due process objection. That was submitted to the record too late. An assessment of good faith has to happen in 2013 when they're acquiring the property. But even then, there is no evidence. Mr. Seda was not asked about this at the hearing. He's the only witness we have that would have been able to testify to this. He was not cross-examined about this. He was not asked any questions about any of this. So there is simply no evidence that establishes anything that they're seeking to extrapolate. So aside from the due process issue of why we objected to having the transcripts admitted with the post-closing submissions, substantively, there is really nothing at all in there that should give rise to any legitimate concern for this tribunal. Aside from the timing issue of this all being 2017, that's what I'll say about the due process objections that have been raised. Well, there's one more thing, and this I will put up a slide. In dealing with the fact that there were Article 22.2, it says nothing in this agreement shall be construed to preclude a party from applying measures. So it can take measures. That's what it's saying. I can adopt a measure if I consider that measure necessary to protect my essential security interest. What does that mean from a timing perspective? It means that I must adopt the measure for that essential security purpose. So I must obviously know about the essential security interest at the time I'm adopting the measure. Otherwise, I'm not adopting a measure to protect my essential security interest if I don't know about the essential security interest at the time, right? So I think this is really important because you can't invoke a measure for an essential security purpose that does not exist at the time you invoke the measure. It goes beyond the good faith analysis. It's the very language of the provision. You must invoke the measure for the essential security purpose. You cannot invoke the measure for a different purpose, which is what they're saying they did in this case, and then later on find out something and say, oh, actually, I also have an essential security purpose. Too late. You had to invoke the measure for that purpose. The WTO cases that we rely on, by the way, in those cases, and if we go back 2 slides, the United States made the same submissions it made in those cases that they're making here. They said it's non-justiciable because those provisions were self-judging. You can see that at 7.52 of the Ukraine-Russia case. They said the United States says that it's non-justiciable. And the panel rejected that. The panel rejected the United States submissions in that case, just like you should do in this case. So the timing issue goes both to the good faith analysis because it can't be plausibly related, but it goes also to the very wording of the provision. The third point I want to briefly touch on is, from a substantive perspective, there is no, and by the way, he wasn't aware when they took the property. He wasn't aware until this arbitration, and nothing in the record suggests otherwise. So from a substantive perspective, it doesn't change anything with respect to the good faith analysis. I can assure you of that. At procedural order number 2, the Redfern schedules, request number 53, Colombia made a request for any evidence relating to third-party funders in this arbitration. And we disclosed that Tenor Capital was funding this arbitration. So unless they're accusing us as counsel of lying or misrepresenting or withholding information from this tribunal, there is no evidence, there's no support for that proposition that anybody other than Tenor Capital is funding this arbitration. I are not going to get any proceeds from this arbitration. And then they say, well, the thing that at the time we took the property, they've already gotten some money for the purchase of the property. And here I want to take you to another slide. The asset forfeiture law itself. So let's assume that Article 16 makes it clear that if assets of legal origin whose value is equivalent to any of the assets described in the preceding numbers, whenever the action is inadmissible due to the recognition of rights of the third party acting in good faith without fault are at issue, then you go after assets of legal origin of those individuals. So what does that mean? It means that if you go to the next slide, please. Dr. Wilson Martinez makes it clear that the correct course of action in that situation would have been to attach the payment rights, the profits of the trustee, and to identify who was a good faith buyer and not affect their property rights. So there's a way to do this. You go after the property that you can, if there is a money laundering cycle here, you can cut off the money laundering cycle by taking and garnishing any of the proceeds that were going to go to illicit third parties, and you preserve the property that is in the hands of the good faith third parties. That's what you're supposed to do. So as Dr. Martinez explained at paragraph 35, once it had been confirmed that Newport was a good faith buyer, we're still waiting for that, is the last thing I want to end on is the preamble, because we heard a little bit about it from Professor Banafitemi earlier. Before I get to the preamble, actually, I want to address something else that Professor Banafitemi mentioned. She said, again, earlier today, that this case is actually premature. And I showed you where something similar was said at I think it was at the opening. Because Newport's good faith is going to be determined. When? When? How long do we have to wait? It cannot be that this case is premature after the property having been taken for 7 years. If it's premature, then you know what they should do? They should never assess Newport's good faith, because then it will forever be premature. No, at some point it is a due process violation. At some point it is a de facto expropriation. At some point it is a national treatment violation when you take some foreign investors' property, but you don't take local investors that are similarly situated. That point passed long ago. Certainly by now, when they told you a year ago that a year from now we'll know, and no progress has been made, certainly by now, this tribunal can conclude that we're past the point of return, that the due process violations of the claimants has been violated, that there has been a de facto expropriation, that there is disparate treatment between nationals whose property has not yet been taken 7 years later and foreign investors whose property was taken 7 years ago. It cannot be that this case is premature. There's clearly been a violation that is crystallized. And I end with the preamble that Professor Banafitemi took you to. This is the purpose of the treaty. This is at the outset of the treaty. The purpose of this treaty is to promote economic development in order to reduce poverty and generate opportunities for sustainable economic alternatives to drug crop production. And I ask the tribunal to consider whether this particular investment was exactly what this treaty was meant to promote. Was this investment advancing narco trafficking? You've heard us talk about this investment. You've heard the jobs that created it, the investment in the hospitality sector, the training, the 700 people on the construction site. I would suggest to you that this was exactly what this treaty was meant to do, and every provision in it, including the essential security provision, must be interpreted in light of this object and purpose, to move on from the drug-ridden history of Colombia and to allow for legitimate economic development like Mr. Seda and investment vehicles engaged in. But that's not what Colombia wants you to do. And I'll end on this slide, this next slide. They said, you know what? Medellin is riddled with a history of drug trafficking. And if there is one legitimate expectation that Mr. Seda should have had, it is that investing in Colombia, when they're investing in one of the worst regions and most dangerous regions. But then how do you ever move on from the history of narco trafficking? And how do you ever develop with legitimate business this economy if basically what they're saying is, no, you can't ever invest here because of that history? That is fundamentally contradictory, and it cannot be what this treaty was meant to achieve. We urge the tribunal to find for the claimants, not just for these claimants, but so that other investors know that if they come and invest in Colombia, they have the protection of this treaty. Subject to any questions, those are our submissions.
Thank you, Mr. Manu. To my two colleagues, do you have questions?
Can I have a quick question, Mr. President?
Yes, certainly.
Mr. Manu, to make sure I understand, you are in effect asking us if we reach the conclusion that there is a violation of the treaty, in particular, if we reach the conclusion that want to call it, you are asking us, aren't you, to reach that conclusion and then to draw from that conclusion that Article 22(2)(b) can no longer be invoked. This is effectively what you're asking, isn't it?
As part of the analysis of whether, that's one of our arguments, Dr. Ponce, is that in doing a good faith analysis, the tribunal should accept that in articulating that essential security interest, protection of narco trafficking, the law itself acknowledges this exception of good faith third parties. And so the tribunal can and should assess whether or not Mr. Seda and the investors were good faith third parties. And that includes an assessment along the lines of what you're saying.
That also means, does it not, that we should not only reach that conclusion, but conclude that even though Mr. Seda et al. Would be in perfect good faith, even though the provision would be invoked, or because the provision of 22(2)b would be invoked, despite that, that would remove the interpretation of 22(2)b that your opponents suggest, namely a sort of, like a red card in a football game, right? Once it's out, everybody stops and the player goes out.
Right.
You're asking us to disregard that.
What we are saying is it's not as simple as a red card that you can just raise and get out of jail free, for many reasons, including that the essential security interest was not identified at the time that the measure was taken. And that's what the provision expressly requires.
But
So
that presupposes, does it not, that we have the right, the power to assess to what extent the 22(2)b exception is raised in good faith. And your opponents vociferously, well, not vociferously, with your opponents challenge that very much.
right. So I would say there's two things. First, just before I get to good faith, just in the interpretation of the provision itself, and if we can go back to 22.2, that slide, they are only able to invoke this provision if they are saying that the measure was taken to protect an essential security interest. They've told you that it was not taken to protect an essential security interest. So this provision does not apply, in my view, because they have told you the measure was taken because of some other reason. It was taken because of Ivan Lopez or whatever the reason was. It was not taken. I think that is undisputed. The measure was not applied to protect the essential security interests because the essential security interest didn't appear, wasn't known until 2022. So setting aside the good faith for a moment, this does not apply because there was no measure that was taken to protect the essential security interests of Colombia. The measure was taken for some other purpose. Ivan Lopez was associated with the title, whatever it was, but they have told you expressly that it was not taken for the essential security purpose that they have now identified. So that's one. The second argument is the good faith argument that we are saying this tribunal, pursuant to Article 26 of the Vienna Convention on the Law of Treaties, and pursuant to the dispute resolution clause in this treaty, has the authority to interpret and to assess whether or not it's being applied in good faith, pursuant to Article 26 of the Vienna Convention on the Law of Treaties, as interpreted by other tribunals.
Thank you.
If there are no further questions, we would then have a short break again before we hear the respondent, meaning 5 to 9 our time, unless you tell us that you don't need 15 minutes.
We would be needing the 15 minutes, Mr. President. Thank you very much.
Okay, then say 5 to 9, yes?
Thank you. Thank you.
All back, Sarah?
Yes, all breakout rooms have been closed.
Very good. So we would invite the respondent for their rebuttal argument, Mrs. Manifatimi. The floor is yours.
Mr. President, Ms. Herrera will say just one word before I continue. Thank you.
Thank you very much.
Yes.
Thank you, Mr. President. One quick point on the interpretation that Mr. Molu had again put forward to this tribunal regarding the asset forfeiture law, and in particular, Article 1610 that he read about going after assets of legal origin when the actual asset is not available, the one of illegal origin, because the action is not admissible. First of all, it's not true that the opinion of Mr. Martinez is unrebutted. It's not true that I actually cross-examined Mr. Martinez on that, and I actually asked him about why he hadn't said nothing about this novel interpretation of that article in his opinion that he provided for Corte Colombiana in 2016. So not only it was a novel interpretation, also the respondents only put it forward in the reply. Second point, please, I refer you to the report of Professor Reyes that explains very clearly paragraphs 179 and following how this operates, Article 10. And in fact, first of all, you have to have a determination that there's a party, bona fide third party, that means that there has been a judgment, and then only then you can go towards an asset of legal origin. Thank you.
And Mr. President, members of the tribunal, I will address very briefly first the second point. I want to take a bit more time on the essential security interest. First of all, there is no issue of due process as regards the claimants. They have had ample opportunity at these 3 times to fully brief the matter, including today, so that nobody can say that they have been restricted in any way in briefing this matter. The first point I want to make on this is the question of good faith, generally. And here I would like to go back to the question of Dr. Ponce. First of all, even though in our submission, this is self-judging, so Colombia does not have to show good faith, Colombia, just to reassure the tribunal, has confirmed that it has raised this exception in full good faith. How do you know it, by the way? You know it from the timeline that I showed you earlier. Colombia did not raise, this is a serious matter, so Colombia did not raise the exception until it was certain and it had evidence, which is the assets that's the subject of this arbitration. So that's how seriously Colombia has taken this matter, and therefore how much in good faith it has acted. So it's not, to respond to Dr. Ponce, it's not late or too late, it's as soon as it became clear to Colombia that the subject matter of this arbitration has to do with narco traffic and the benefit of this arbitration to narco traffickers. And so you do have the evidence, and you have to look at that evidence and make a determination on that basis if you are going to look at the good faith issue, where in the alternative, of course, in relation to the invocation of the exception. So you cannot ignore that evidence. That is an extremely serious matter. You cannot ignore that evidence. It is before you, and it's not enough for Mr. Molu to say, I don't like that evidence, therefore it doesn't exist. That's the first point I wanted to make on the invocation of the essential security interest. The second point I want to make is that, again, going to the timing, and that's also to Dr. Ponce's question, there is no statute of limitation. Article 22.2 doesn't say at what point in time it can be raised, in what manner. It is a full discretion of the state who makes that determination when the state makes the determination that this is in the protection of its essential security interest. So no statute of limitation. Now addressing the question of Professor Perez-Cano, and the rejoinder specifically, the position has evolved, but it has not evolved today. The position evolved last year. As you may recall, the justiciability and then the fact that this is non-justiciable arose at the hearing, and that's the time at which we argued non-justiciability as an additional ground. So, and the three layers that you have, one, non-justiciable, in the alternative, no jurisdiction, in the alternative, further alternative, raised in good faith. So you have the three layers, and that was last year during the hearing, nothing new there. So this is our position indeed. Our position is that this is non-justiciable for all the reasons that we have given. And if you recall at that time, it was also after we had access to the travaux préparatoires, and that the travaux préparatoires showed indeed that the parties did raise the matter as a non-justiciable matter. So that is the evolution of the position in last year at the hearing after we had access to the travaux préparatoires. Now, one point that Mr. Molu made is that this is somehow a merits defense. This is not a merits defense. This is a defense that goes to the power of the tribunal. Non-justiciable means that there is no legal review by anyone in a tribunal, for that matter, of the circumstances in which the exception is invoked. So that's not a merits defense, that is a power defense. You do not have the power. That's the first layer. In the alternative, you do not have the jurisdiction. In the third layer, it's even before merits. In the third alternative, it's you, if you would like to determine the good faith, you have ample evidence to show that this is indeed has been raised in good faith, and the timeline and everything else that we discussed today shows that. And then you go to the merits, and on the merits, this doesn't apply. So it's wrong for Mr. Molu to confuse justiciability with the merits issue. Now, on the provision itself, nothing in this agreement shall be construed to preclude a party from applying measures. Mr. Molu is trying to confuse the matter and say that the measure was taken at some point in time, and therefore at that time, the measure was applied. Again, you have to read the text for what it says. The text says that nothing in this agreement, this is a very broad exclusion, shall be construed to preclude the party from applying measure. What it means that the state can apply measures that it considers necessary for the protection of its essential security interest. What it means is that therefore there cannot be any assessment, any adjudication of the application of those measures. And what it means is that therefore there is a whole exception of the application of the treaty to those measures. I refer you to exactly what the US said earlier today. This is the home state of the claimants, and this is our counterparty to the treaty. I quote, referring to the claimants' point that, I quote, the exception supports the conclusion that Article 22(2)b merely allows the state to continue to apply measures. The US government said, I quote, the US disagrees. Article 22(2)b is an exception that is intended to entirely exclude from the scope of the obligation and the TPA those measures covered by Article 22(2)b. As there is no obligation under the TPA with respect to covered measure, a claimant cannot establish that per Article 1016, etc. And I discussed that earlier. So it is indeed a derogation, an entire exclusion of the treaty once the provision has been invoked. Now, Mr. Molu refers to the GATT and the fact that the US was not followed in the GATT. As you know, the GATT has a completely different provision. It has a list of 3 specific circumstances. Therefore, the panel in the GATT decided that on a very limited standard of review, they will look at whether one of those circumstances is fulfilled. You don't have that here. This is a very broad exclusion, which says measures that it considers necessary for the protection of its internal security interests. There is no list. There is no specific circumstances that a tribunal can double check. And if you look at the actual case law, there is no case law. And that's why he likes Ecuador, he likes the GATT. There is no case law in relation to the provision that we have. No tribunal has ever rendered a decision on this basis. You would be the first tribunal. So you have a very heavy responsibility of applying correctly what the true states are telling you. In this case, this is an authentic interpretation. This is how this should be read, and this is binding on this tribunal. This takes me, I believe, to the last point, Mr. President, and this is in response to your question. And I think I have about 3 or 4 sub matters to address here. The first is, maybe I should start, in fact, by addressing what Mr. Mulu said about, and he takes issue, 7 years, oh my God, this is very long, and de facto expropriation, and so on and so forth. What they do not tell you, or they don't remind you of, is that those 7 years, you have had one appeal, which was successful for Newport, where Newport sought to be recognized as an afectado. Having been recognized, so they used the remedies under Colombian law, they were successful in that relation, and they now have been admitted as afectado party. So that's time they have benefited from the Colombian law remedies. You had COVID, of course, and COVID has had an impact. You cannot ignore that either. And the third is that what they don't tell you is that they currently have an appeal ongoing where they're asking the court to annul the entire asset forfeiture proceeding. They are taking benefits of the remedies under Colombian law, and that is time. So they are taking advantage of the remedies under Colombian law. They cannot come back and complain that this takes time. If they're appealing, the appeal will take time, and the Colombian law, Colombia is governed by the rule of law, and the Colombian courts will look at very carefully the cases that are brought before them. That's the first point I want to make. The second point goes to very specific your question, Mr. President, the what is the exception and what is the invocation of the exception? Referring to a question, Colombia is not saying that the exception is the law itself. The law, and you will remember from Article 34 of the Constitution, has a much broader scope. If you look at Article 34, it refers to illegal means, assets acquired by illegal means to the detriment of the Treasury or resulting in severe deterioration of social morals. This is the categories that are addressed in Article 34. So asset forfeiture proceedings can address situations that have nothing to do with narco traffic. You can have a situation of an asset that is seized in relation to, for example, prostitution of minors. That is social morals. That is not narco traffic. It's a very serious matter as well. And that is going to the protection of the social morals. So the scope of the law is broader than the narco traffic. Historically, narco traffic is one of the main goals of the law, but it's not the only goal of the law. So the law is broader. In this case, there is an overlap between one of the raison d'etre, one of the rationales of the law, which is also fight against narco traffic and organized crime. That's one, but not the only. And the invocation by Colombia of the essential security. So the essential security is not the law itself. It's an in concreto determination by Colombia that the proceedings that are ongoing concern organized crime, and that the process is to avoid further money laundering. So it's that measure. It's not the law itself. It's not the law as such. It's in concreto the invocation of that specific proceeding affecting the money laundering to the benefit of narco traffickants. Now, as to the exception in the exception, these are two different things. You have the domestic plane and you have the international plane. The domestic plane is the fact that Colombian courts will have jurisdiction to make a determination based on the law in narco traffic or more generally. They can make a determination as to whether or not the rights of third parties who are bona fide have been preserved or should be preserved. That is something that's within the power of domestic courts. That's not something that's in the power of this tribunal. This tribunal has no means, no power, no evidence, no argument, nothing before it to make that determination. That is not the realm of this tribunal. So the exception, which is before the domestic courts, which Newport has taken fully the benefit of, and as you know now they are appealing before the domestic courts, they have a remedy. The remedy is Colombian law, the remedy is before the Colombian courts, and they will have an answer. That's why we say it's premature. And it is indeed premature, and they have taken the full advantage of what Colombian law says, and they cannot complain about time because these matters take time. And this tribunal is not called upon to make a determination of denial of justice, because justice has not been rendered yet. Justice is ongoing in Colombia. You have to trust the judiciary in Colombia. You have to trust the rule of law in Colombia. You have to trust that Colombia is doing it right. Now, that's the domestic level. On the international level, which is your concern, and now I'm in the alternative number 2, which is, should you decide that it's not self-judging? We say, of course, you shouldn't. Should you decide that it's within your jurisdiction? We say, of course, you shouldn't. But let's assume that you say that you have the jurisdiction to determine whether the invocation was in good faith. That determination is a very minimum restricted prima facie test of plausibility. What you have to determine is whether, not whether there is a benefit of whether Newport is a good faith third party. That's for the courts in Colombia to determine. What you have to determine in relation to whether this is a good faith invocation is whether the asset forfeiture proceedings as they're ongoing and the invocation by Colombia is indeed for the protection of its essential security interest in the form of fight against money laundering and narco traffic. So that is what we have said, and that's in my slide 69. Our position is that we seek through the proceedings to fight organized crime, money laundering, and drug trafficking. So it's not the law itself, it's the fact that the proceedings that are ongoing are to ensure that there is no money laundering to the benefit of narco traffickers and organized crime. This is the purpose, this is the essential security that Colombia is trying to safeguard. And your task, should you be in that further alternative, is to look at whether that's a plausible explanation about the proceeding itself and that protection of fight against organized crime. That's the international level, which is completely different from the domestic level, which is in the realm of the domestic courts, which again, Newport has taken the full advantage of before the domestic courts. I hope that I have addressed all of the questions that were asked of me, but of course I'm in your hands if I haven't. Thank you, Mr. President.
Thank you very much. I again turn to my 2 colleagues. Do you have questions?
I don't have any, Mr. Chairman. Thank you.
I do have one, Chair.
Yes, please.
Ms. Benefitimi referred to it in her opening submissions and again in her closing submissions to the ongoing judicial proceedings, the asset forfeiture proceedings. She referred to an appeal by Newport having filed, if I heard her correctly, I think in May last year. So I assume it must have taken place sort of contemporaneously when we met for our hearing. The prior appeal, that one that was resolved, that admitted Newport as an afectado, and which was issued, the decision was issued in April 2022, so just before our hearing. That when the appeal was filed, it was admitted in the efecto suspensivo, meaning that the proceedings before the judge of first instance were suspended. So my question, given that this has come up, and in light of Mr. Molu's comment that nothing has happened since, what is, was the appeal filed in May last year also in the efecto suspensivo? Are the proceedings before the first instance judge currently suspended? Are they ongoing? What's the status? If Ms. Benefiteni can tell me, or perhaps Ms. Ordóñez, who is a representative within the government, probably knows. Thank you.
Thank you, Professor Provescano. Would you allow me 1 minute just to consult internally?
Yes, of course.
Thank you so much. Professor Provescano, thank you for your patience. Mr. Giovanni Vega Barbosa will respond to this question on behalf of Colombia. Thank you.
Thank you, Jess. As for the clarity of the tribunal, Ms. Ana Maria Ordóñez referred to an appeal that was raised by Newport in mid-2022, not May. We saw the record, and it was indeed written that the appeal was filed in May 2022, but it was presented in July 2022. It was a request for an annulment of the whole asset forfeiture proceeding, which was denied in first instance by the asset forfeiture court, and then referred in the devolutive effect to the special chamber of asset forfeiture of the Tribunal Superior de Bogotá. The decision is currently pending by the Tribunal Superior de Bogotá, which, as you know, is the court of last instance for matters concerning asset forfeiture in Colombia.
Okay, so just to be clear, the underlying procedures are not suspended.
No,
Okay.
it was the request was granted in the devolutive effect, but no decision has been made so far as to the request of the total annulment of the proceedings. Yes, that's correct.
Thank you.
And from my understanding, by underlying proceeding, are you referring, Hugo, to the proceeding in which recently in 2002, Newport was recognized as being intervening party?
No,
Yes,
I'm sorry, my question really was, in the prior appeal that was decided in April 2022, the effect when the appeal was filed, and I forget exactly when it was, I think it was 2018 or 2019. And whenever it was, the effect of Newport filing the appeal was to suspend the whole asset forfeiture proceedings until the decision was rendered in April 2022. So my question was, with this new appeal, whether the asset forfeiture proceedings were again suspended or they are ongoing. And I understood Mr. Giovanni to have said, no, they did not suspend the proceedings, they continue.
Yeah, the judge of first instance granted the request for appeal in the devolutive effect, not in the suspensive effect. But if I may add, this is not a request for an afectado to be recognized. It's a request for the annulment of the asset forfeiture proceedings. And in response to Professor Sachs, yes, it refers to the same asset forfeiture proceeding, which is the subject matter of this arbitration.
Right, but forgive me, but in order to have a clear picture, my understanding was that the proceedings before the Colombian court concerned the question whether the asset forfeiture law was applied correctly in this case, or incorrectly, meaning that the good faith acquisition was the subject matter. Is my understanding correct that this proceeding, the one on the good faith issue, is still ongoing, and it has now been clarified in April 2022 that Newport has a role in these proceedings, namely as an intervening party. And so what is the interaction between these proceedings and the appeal that you mentioned? The appeal, which I understand was lodged by Newport in order to annul the whole asset forfeiture. So this is not clear to me how they interrelate.
May I respond?
Yes, please.
Yes, the whole purpose of these proceedings is to determine whether Newport is a qualified good faith buyer. And for those purposes, Newport has standing to prove its qualified good faith status since the moment it was recognized as an afectado. In that process, or in that proceeding, we are at this very moment in the evidence or evidentiary stage of the proceedings. Because of our request or upon a request by Prosecutor Caro to introduce some supervening evidence into the proceedings, or on the occasion of that request, Newport filed a request for the nullity of the whole proceedings. That is the same proceedings in which they are requesting to be recognized as qualified good faith buyers.
I understand. And those new elements, are those the ones
involved with the Meritage case? And the decision regarding those pieces of evidence, as far as we know, but if we are allowed, we're more than happy to confirm this to the tribunal afterwards. But as far as we know, this is evidence that was granted by the judge of first instance, and it was on the basis of the decisions made on these new pieces of evidence that the request for nullity was filed by Newport in mid-2022.
Thank you. And I now give the floor to the claimant to comment, to confirm or correct or complement what was just said.
Mr. President, my understanding is that the underlying proceedings with respect to the determination of Newport's good faith have not been paused. So I think that we share that understanding. They have not been paused formally, I should say, but no progress has been made in those proceedings, to our knowledge. I should also mention that Newport obviously has not just foreign investor interests, but domestic investors. So there are additional parties that are interested in Newport that are not before this tribunal, of course. But if it's helpful, because our Colombian counsel is not on the line, we can provide just a very short email update of what clarification on this specific question. I'm not proposing any further submissions or anything like that, but just a clarification on this question, if it would be helpful for the tribunal.
I think the tribunal would welcome from both sides a very, very short update on those proceedings. No further submissions, just update,
Right.
Confirming what you just said. Could we have that within a week?
Yes, no problem, Mr. President.
And ideally, what I would suggest is that you contact each other so that we get a joint paper.
We will endeavor to do so.
Okay, very good. Anything else, my two colleagues, or are we through with our questions?
By me, Mr. President.
No further questions from me.
Okay.
Thank you.
No further question from me either. This brings us to the end of this third hearing. We thank.
I believe, Mr. President, Dr. Ponce had a question, but I may be mistaken.
Oh, I'm sorry. Jean, you had a question? I thought you had not. Again.
Sorry, I was on mute. No. I said no questions as far as I'm concerned. Thank you.
Apologies, I misheard.
No.
Mr. President, Sarah here. Just wanted to note one thing. The question of the statements of cost, according to PO1, must be discussed at the end of the hearing. I don't know if you want to discuss this now or.
Yes, I was going to discuss this. Thank you for reminding me, Sarah. Indeed, we have to shortly discuss the question of cost submission, the deadlines, and the details. Have you had the chance to talk to each other how to handle this, or would you prefer to make a joint proposal as to both the timing of such submissions and also the level of detail that you agree should be included in the statements?
We have not had a chance, Mr. President, to discuss among parties, but we're happy to do so and revert to the tribunal if that's of assistance.
Mr. Malou, would you agree?
Yes, Mr. President.
Fine. So if there is a problem that we have to solve, then please tell us, but otherwise we will look forward to receiving your joint proposal. Transcript, I don't expect there to be many problems. We have already received a rough transcript, but in case there is a problem, please let us know. Otherwise, let's agree that if we don't hear from you, to the contrary, the final version of the transcript will be the one that is relevant and conclusive. Let's say within 2 weeks. That's the deadline for you to tell us whether there's a problem or whether corrections need to be done, in which case we would again invite you to liaise to come up with a joint proposal. Is that too short?
That should be workable, Mr. President.
Very good.
Likewise on our side, Mr. President.
Thank you very much. Then I am afraid this was the last hearing in this case. We thank you, both sides, also for this hearing. We think it was helpful. You made your positions clear in a very efficient and professional way. Thank you. I also want to thank Sarah for having organized all this, and of course David and Dante for their unfortunately invisible assistance, but we see the product, so that's good. And with that, we will close today's hearing, and we will first hear from you, and then you will hear from us.
Thank you, and good evening.
Thank you, Mr. President. Thank you, members of the tribunal.
Thanks very much.
Bye-bye.
Sarah, could you switch us to the breakout room, please?